After considering all the evidence, if you decide the prosecution has proven each of the elements of a crime charged beyond a reasonable doubt, you should find Ms. Rodriguez guilty of that crime. After considering all the evidence, if you decide the prosecution has failed to prove any one or more of the elements of a crime charged beyond a reasonable doubt, you should find Ms. Rodriguez not guilty of that crime. You should not allow bias or any kind of prejudice based upon gender, race, or ethnicity to influence your decision. A fact may be proven by either direct or circumstantial evidence. Under the law, both are acceptable ways to prove something. Neither is necessarily more reliable than the other. Direct evidence is based on first-hand observation of the fact in question. For example, a witness's testimony that she looked out a window and saw snow falling might be offered as direct evidence that it had snowed. Circumstantial evidence is indirect. It is based on observations of related facts that may lead you to reach a conclusion about the fact in question. For example, a witness's testimony that she looked out a window and saw snow covering the ground might be offered as circumstantial evidence that it had snowed. You are the sole judges of the credibility of each witness and the weight to be given to the witness's testimony. You should carefully consider all of the testimony given and the circumstances under which each witness has testified. For each witness, consider that person's knowledge, motive, state of mind, demeanor, and manner while testifying. Consider the witness's ability to observe, the strength of that person's memory, and how that person obtained his or her knowledge. Consider any relationship the witness may have to either side of the case and how each witness might be affected by the verdict. Consider how the testimony of the witness is supported or contradicted by other evidence in the case. You should consider all facts and circumstances shown by the evidence when you evaluate each witness's testimony. You may believe all of the testimony of a witness, part of it, or none of it. You are not bound by the testimony of witnesses who have testified as experts. The credibility of an expert's testimony is to be considered as that of any other witness. You may believe all of an expert witness's testimony, part of it, or none of it. The weight you give the testimony is entirely your decision. The number of witnesses testifying for or against a certain fact does not by itself prove or disprove that fact. The court admitted certain evidence for a limited purpose. Specifically, the testimony regarding prior abuse between Ms. Varela and Ms. Rodriguez was presented for the limited purpose of failure to report the crimes prosecuted in this matter only. You are again instructed that you cannot consider that evidence except for the limited purpose I told you about when it was admitted. In this case, a separate offense is charged against Ms. Rodriguez in each count of the information. Each count charges a separate and distinct offense, and the evidence and the law applicable to each count should be considered separately, uninfluenced by your decision as to any other count. The fact that you may find Ms. Rodriguez guilty or not guilty of one of the offenses charged should not control your verdict as to any other offense charged against the defendant. Ms. Rodriguez may be found guilty or not guilty of any one or all of the offenses charged. In this case, certain words and phrases have particular meanings. Accordingly, you are to use the following definitions where these words and phrases appear in instructions that define crimes and verdict questions. Benefit means any gain or advantage to the beneficiaries, including any gain or advantage to another person pursuant to the desire or consent of the beneficiary. Building means a structure which has the capacity to contain and is designed for the shelter of man, animals, or property, and includes a ship, trailer, sleeping car, airplane, or other vehicle or place adapted for overnight accommodations of persons or animals, or for carrying on of business therein, whether or not a person or animal is actually present. A building of another is a unit in a building divided into units for separate occupancy that is not occupied by the defendant. Property is that of another if anyone other than the defendant has a possessory or proprietary interest therein. Dwelling means a building which is used, intended to be used, or is usually used by a person for habitation. A person enters unlawfully or remains unlawfully in or upon premises when the person is not licensed, invited, or otherwise privileged to do so. A person who, regardless of her intent, enters or remains in or upon premises that are at the time open to the public does so with license and privilege unless the person defies a lawful order not to enter or remain personally communicated to her by the owner of the premises or some other authorized person. A license or privilege to enter or remain in a building that is only partly open to the public is not a license or privilege to enter or remain in that part of the building that is not open to the public. Occupied structure means any area, place, facility, or enclosure which, for particular purposes, may be used by persons or animals upon occasion, whether or not it is a building, and which is in fact occupied by a person or animal and known by the defendant to be thus occupied at the time of the alleged offense. Official proceeding means a proceeding heard before any legislative, judicial, administrative, or other government agency or official authorized to hear evidence under oath, including any magistrate, hearing, examiner, commissioner, notary, or other person taking testimony or depositions in any such proceedings. Person, when referring to the victim of a homicide, means a human being who had been born and was alive at the time of the homicidal act. Bodily injury means physical pain, illness, or any impairment of physical or mental condition. Great bodily injury means bodily injury which, either at the time of the actual injury or at a later time, involves a substantial risk of death, a substantial risk of serious permanent disfigurement, a substantial risk of protracted loss or impairment of the function of any part or organ of the body, or breaks, fractures, or burns of the second or third degree. Deadly physical force means force, the intended, natural, and probable consequence of which is to produce death, and which does, in fact, produce death. Intoxication means a disturbance of mental or physical capacities resulting from the introduction of any substance into the body. Deadly weapon means a knife, bludgeon, or any other weapon, device, instrument, material, or substance, whether animate or inanimate, that in the manner it is used or intended to be used is capable of producing death or serious bodily injury. A deadly weapon also means a firearm, whether loaded or unloaded. Serious bodily injury means bodily injury that, either at the time of the actual injury or at a later time, involves a substantial risk of death, a substantial risk of serious permanent disfigurement, a substantial risk of protracted loss or impairment of the function of any part or organ of the body, or breaks, fractures, a penetrating knife or penetrating gunshot wound, or burns of the second and third degree. A crime is committed when the defendant has committed a voluntary act prohibited by law together with a culpable state of mind. Voluntary act means an act performed consciously as a result of effort or determination. Proof of the voluntary act alone is insufficient to prove that the defendant had the required state of mind. The culpable state of mind is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt, either by direct or circumstantial evidence. In this case, the applicable states of mind are explained below. The term after deliberation means not only intentionally, but also that the decision to commit the act has been made after the exercise of reflection and judgment concerning the act. An act committed after deliberation is never one which has been committed in a hasty or impulsive manner. A person acts intentionally or with intent when his conscious objective is to cause the specific result prescribed by the statute defining the offense. It is immaterial whether or not the result actually occurred. A person acts knowingly or willfully with respect to conduct or to a circumstance described by a statute defining an offense when she is aware that her conduct is of such a nature or that such a circumstance exists. A person acts knowingly or willfully with respect to a result of her conduct when she is aware that her conduct is practically certain to cause the result. A person acts recklessly when she consciously disregards a substantial and unjustifiable risk that a result will occur or that a circumstance exists. The elements of the crime of murder in the first degree are that Stacy Rodriguez, in the state of Colorado, at or about the date and place charged, after deliberation and with the intent to cause the death of a person other than herself, caused the death of Christopher Dickerson, and that the defendant's conduct was not legally authorized by the affirmative defenses in instructions number 16 and 17. After considering all of the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Ms. Rodriguez guilty of murder in the first degree. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find Ms. Rodriguez not guilty of murder in the first degree. If you are not satisfied beyond a reasonable doubt that Ms. Rodriguez is guilty of the offense charged, he may, however, be found guilty of any lesser offense, the commission of which is necessarily included in the offense charged, if the evidence is sufficient to establish her guilt of the lesser offense beyond a reasonable doubt. The offense of murder in the first degree after deliberation, as charged in the information in this case, necessarily includes the lesser offenses of murder in the second degree and manslaughter. You are not required to deliberate on the charged offense before considering or deliberating on the lesser included offenses. The elements of the crime of murder in the second degree are that Stacy Rodriguez, in the state of Colorado, at or about the date and place charged, knowingly caused the death of another person. The elements of the crime of manslaughter are that Stacy Rodriguez, in the state of Colorado, at or about the date and place charged, recklessly caused the death of another person. You should bear in mind that the burden is always upon the prosecution to prove beyond a reasonable doubt each and every element of any lesser included offense which is necessarily included in any offense charged in the information. The law never imposes upon a defendant in a criminal case the burden of calling any witnesses or producing any evidence. After considering all the evidence, if you decide that the prosecution has proven each of the elements of the crime charged or of a lesser included offense, you should find Ms. Rodriguez guilty of the offense proven, and you should so state in your verdict. After considering all the evidence, if you decide that the prosecution has failed to prove one or more elements of the crime charged and one or more elements of any lesser included offense, you should find Ms. Rodriguez not guilty of these offenses, and you should so state in your verdict. While you may find the defendant not guilty of the crime charged and the lesser included offenses, you may not find Ms. Rodriguez guilty of more than one of the following offenses: murder in the first degree, murder in the second degree, and manslaughter. The evidence presented in this case has raised the affirmative defense of defensive person as a defense to murder in the first degree or murder in the second degree. Ms. Rodriguez was legally authorized to use physical force upon another person without first retreating if she used that physical force in order to defend herself or a third person from what she reasonably believed to be the use or imminent use of unlawful physical force by that other person, and she used a degree of force which she reasonably believed to be necessary for that purpose, and she did not, with the intent to cause bodily injury or death to another person, provoke the use of unlawful physical force by that other person, and she was not the initial aggressor, or if she was the initial aggressor, she had withdrawn from the encounter and effectively communicated to the other person her intent to do so, and the other person nevertheless continued or threatened the use of unlawful physical force. The reasonable person standard requires Ms. Rodriguez to appraise the situation as would a reasonable sober person. The prosecution had the burden to prove beyond a reasonable doubt that Ms. Rodriguez's conduct was not legally authorized by this defense. In order to meet this burden of proof, the prosecution must disprove beyond a reasonable doubt at least one of the above numbered conditions. After considering all the evidence, if you decide the prosecution has failed to meet this burden of proof, then the prosecution has failed to prove Ms. Rodriguez's conduct was not legally authorized by this defense, which is an essential element of murder in the first degree or murder in the second degree. In that event, you must return a verdict of not guilty to those offenses. After considering all the evidence, if you decide the prosecution has met this burden of proof, then the prosecution has proved Ms. Rodriguez's conduct was not legally authorized by this defense. In that event, your verdict concerning the charges of murder in the first degree or murder in the second degree must depend upon your determination whether the prosecution has met its burden of proof with respect to the remaining elements of those offenses. And ladies and gentlemen, if you can give me just a moment here, please. Ladies and gentlemen of the jury, I do see that there is a mistake in instruction number 14. I'm going to refer you back to instruction number 14. That is the instruction dealing with the elements of the crime of murder in the first degree. Element 7 states that the defendant's conduct was not legally authorized by the affirmative defenses in instructions number 16 and 17. That should read instructions number 16, 17, and instruction 20. I am going to make that change to the official version of the jury instructions when you receive them. If you will please also add 16, 17, and 20 to your versions as well. To resume with instruction 17. The evidence presented in this case has raised the affirmative defense of deadly physical force in defense of person as a defense to murder in the first degree or murder in the second degree. Ms. Rodriguez was legally authorized to use deadly physical force upon another person without first retreating if she used that deadly physical force in order to defend herself or a third person from what she reasonably believed to be the use or imminent use of unlawful physical force by that other person, and she reasonably believed a lesser degree of force was inadequate, and she had a reasonable ground to believe and did believe she was in imminent danger of being killed or receiving great bodily injury, and she did not, with the intent to cause bodily injury or death to another person, provoke the use of unlawful physical force by that other person, and she was not the initial aggressor, or if she was the initial aggressor, she had withdrawn from the encounter and effectively communicated to the other person her intent to do so, and the other person nevertheless continued or threatened the use of unlawful physical force. The reasonable person standard requires Ms. Rodriguez to appraise the situation as would a reasonable, sober person. The prosecution has the burden to prove beyond a reasonable doubt that the defendant's conduct was not legally authorized by this defense. In order to meet this burden of proof, the prosecution must disprove beyond a reasonable doubt at least one of the above numbered conditions. After considering all the evidence, if you decide the prosecution has failed to meet this burden of proof, then the prosecution has failed to prove Ms. Rodriguez's conduct was not legally authorized by this defense, which is an essential element of murder in the first degree and murder in the second degree. In that event, you must return a verdict of not guilty of those offenses. After considering all the evidence, if you decide the prosecution has met this burden of proof, then the prosecution has proved Ms. Rodriguez's conduct was not legally authorized by this defense. In that event, your verdict concerning the charges of murder in the first degree and murder in the second degree must depend on your determination whether the prosecution has met its burden of proof with respect to the remaining elements of those offenses. The evidence presented in this case has raised the question of self-defense with respect to manslaughter. A person is justified in using physical force upon another person without first retreating in order to defend herself from what she reasonably believes to be the use or imminent use of unlawful physical force by that other person, and she may use a degree of force which she reasonably believes to be necessary for that purpose. However, a person is not justified in using physical force if, with the intent to cause bodily injury or death to another person, she provokes the use of unlawful physical force by that other person, or she is the initial aggressor, except that her use of physical force upon another person under the circumstances is justifiable if she withdraws from the encounter and effectively communicates to the other person her intent to do so. But the other person nevertheless continues or threatens the use of unlawful physical force. The reasonable person standard requires Ms. Rodriguez to appraise the situation as would a reasonable, sober person. You have been instructed that the prosecution has the burden of proving beyond a reasonable doubt all of the elements of manslaughter, including that the defendant acted recklessly. You are further instructed that with respect to manslaughter, the prosecution does not have an additional burden to disprove self-defense. You are instructed, though, that a person does not act recklessly if her conduct is legally justified as set forth above. The evidence presented in this case has raised the question of self-defense with respect to manslaughter. A person is justified in using deadly physical force upon another person without first retreating in order to defend herself or a third person from what she reasonably believes to be the use or imminent use of unlawful physical force by that other person if she reasonably believes a lesser degree of force is inadequate and she has a reasonable ground to believe and does believe that she or another person is in imminent danger of being killed or of receiving great bodily injury. However, a person is not justified in using deadly physical force if, with the intent to cause bodily injury or death to another person, she provokes the use of unlawful physical force by that other person, or she is the initial aggressor, except that her use of physical force upon another person under the circumstances is justifiable if she withdraws from the encounter and effectively communicates to the other person her intent to do so. But the other person nevertheless continues or threatens the use of unlawful physical force. The reasonable person standard requires Ms. Rodriguez to appraise the situation as would a reasonable, sober person. You have been instructed that the prosecution has the burden of proving beyond a reasonable doubt all of the elements of manslaughter, including that the defendant acted recklessly. You are further instructed that, with respect to manslaughter, the prosecution does not have an additional burden to disprove self-defense. You are instructed, though, that a person does not act recklessly if her conduct is legally justified as set forth above. The evidence presented in this case has raised the affirmative defense of deadly physical force in defense of a person as a defense to murder in the first degree and murder in the second degree. Stacy Rodriguez was legally authorized to use deadly physical force upon another person without first retreating if she used that deadly physical force in order to defend herself or a third person from what she reasonably believed to be the use or imminent use of unlawful physical force by that other person, and she reasonably believed a lesser degree of force was inadequate, and the other person was committing or reasonably appeared about to commit assault in the first degree, as reflected in jury instructions 21 and 22, or assault in the second degree, as reflected in jury instructions 23, 24, and 25. And she did not, with the intent to cause bodily injury or death to another person, provoke the use of unlawful physical force by that other person, and she was not the initial aggressor, or if she was the initial aggressor, she had withdrawn from the encounter and effectively communicated to the other person her intent to do so, and the other person nevertheless continued or threatened the use of unlawful physical force. The reasonable person standard requires Ms. Rodriguez to appraise the situation as would a reasonable, sober person. The prosecution has the burden to prove beyond a reasonable doubt that the defendant's conduct was not legally authorized by this defense. In order to meet this burden of proof, the prosecution must disprove beyond a reasonable doubt at least one of the above-numbered conditions. After considering all the evidence, if you decide the prosecution has failed to meet this burden of proof, then the prosecution has failed to prove the defendant's conduct was not legally authorized by this defense, which is an essential element of murder in the first degree and murder in the second degree. In that event, you must return a verdict of not guilty of those offenses. After considering all the evidence, if you decide the prosecution has met this burden of proof, then the prosecution has proved the defendant's conduct was not legally authorized by this defense. In that event, your verdict concerning the charges of murder in the first degree and murder in the second degree must depend upon your determination whether the prosecution has met its burden of proof with respect to the remaining elements of those offenses. The elements of the crime of assault in the first degree deadly weapon are that an individual in the state of Colorado with intent to cause serious bodily injury to another person cause serious bodily injury to any person by means of a deadly weapon. The elements of the crime of assault in the first degree permanent disfigurement are that an individual in the state of Colorado with intent to disfigure another person seriously and permanently or to destroy, amputate, or disable permanently a member or organ of another person's body cause such injury to any person. The elements of the crime of assault in the second degree bodily injury with a deadly weapon are that an individual in the state of Colorado with intent to cause bodily injury to another person cause such injury to any person by means of a deadly weapon. The elements of the crime of assault in the second degree reckless are that an individual in the state of Colorado recklessly caused serious bodily injury to another person by means of a deadly weapon. The elements of the crime of assault in the second degree, intent to cause bodily injury, causing serious bodily injury, are that an individual in the state of Colorado with intent to cause bodily injury to another person cause serious bodily injury to that person or another person. The elements of the crime of first-degree arson are that Stacy Rodriguez in the state of Colorado at or about the date and place charged knowingly set fire to, burned, or caused to burn any building or occupied structure of another without that person's consent. After considering all of the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Ms. Rodriguez guilty of first-degree arson. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find Ms. Rodriguez not guilty of first-degree arson. If you find the defendant not guilty of first-degree arson, you should disregard this instruction and sign the verdict form to indicate your not guilty verdict. If, however, you find the defendant guilty of first-degree arson, you should sign the verdict form to indicate your finding of guilt and answer the following verdict question on the verdict form. Did the prosecution prove beyond a reasonable doubt that the arson was of an occupied structure? Answer yes or no. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. The elements of the crime of tampering with a deceased human body are that Stacy Rodriguez, in the state of Colorado, at or about the date and place charged, believed that an official proceeding was pending, in progress, or about to be instituted, and acting without legal right or authority, willfully destroyed, mutilated, concealed, removed, or altered a human body, part of a human body, or human remains, with intent to impair its or their appearance or availability in the official proceedings. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Ms. Rodriguez guilty of tampering with a deceased human body. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find Ms. Rodriguez not guilty of tampering with a deceased human body. The elements of the crime of second-degree burglary arson are that Stacy Rodriguez, in the state of Colorado, at or about the date and place charged, knowingly broke an entrance into, entered unlawfully in, or remained unlawfully after a lawful or unlawful entry in a building or occupied structure with intent to commit therein the crime of arson as defined in Instruction 30 against another person or property. After considering all of the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Ms. Rodriguez guilty of second-degree burglary. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find Ms. Rodriguez not guilty of second-degree burglary. The elements of the crime of arson are that the defendant, Stacy Rodriguez, in the state of Colorado, at or about the date and place charged, knowingly set fire to, burned, or caused to be burned a building or occupied structure of another without that person's consent. If you find the defendant not guilty of the crime of second-degree burglary arson, you should disregard this instruction and sign the verdict form to indicate your not guilty verdict. If, however, you find the defendant guilty of the crime of second-degree burglary arson, you should sign the verdict form to indicate your finding of guilt and answer the following verdict question on the verdict form. Was the burglary of a dwelling? Answer yes or no. The burglary was of a dwelling only if the structure burglarized by the defendant was a dwelling as defined in Instruction 12. The prosecution has the burden to prove the numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. The elements of the crime of secondary burglary theft are that Stacy Rodriguez, in the state of Colorado, at or about the date and place charged, knowingly broke an entrance into, entered unlawfully in, or remained unlawfully after a lawful or unlawful entry in a building or occupied structure with intent to commit therein the crime of theft as defined in Instruction 33 against another person or property. After considering all of the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find Ms. Rodriguez guilty of second-degree burglary. After considering all of the evidence, if you decide the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you should find Ms. Rodriguez not guilty of second-degree burglary. The elements of the crime of theft are that the defendant, Stacy Rodriguez, in the state of Colorado, at or about the date and place charged, knowingly obtained, retained, or exercised control over anything of value of another without authorization or by threat or deception, and intended to deprive the other person permanently of the use or benefit of the thing of value. And, we'll continue to Instruction 34. If you find the defendant not guilty of the crime of second-degree burglary theft, you should disregard this instruction and sign the verdict form to indicate your not guilty verdict. If, however, you find the defendant guilty of the crime of second-degree burglary theft, you should sign the verdict form to indicate your finding of guilt and answer the following verdict question on the verdict form. Was the burglary of a dwelling? Answer yes or no. The burglary was of a dwelling only if the structure burglarized by the defendant was a dwelling as defined in Instruction 12. The prosecution has the burden to prove the numbered condition beyond a reasonable doubt. After considering all the evidence, if you decide the prosecution has met this burden, you should mark yes in the appropriate place and have the foreperson sign the designated line of the verdict form. After considering all the evidence, if you decide the prosecution has failed to meet this burden, you should mark no in the appropriate place and have the foreperson sign the designated line of the verdict form. Members of the jury, you may only discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or anyone else at any other time except when all jurors are in the jury room. Once you begin your deliberations, if you have a question, your foreperson should write it on a piece of paper, sign it, and give it to the bailiff, who will bring it to me. The court will then determine the appropriate way to answer the question. However, there may be some questions that, under the law, the court is not permitted to answer. Please do not speculate about what the answer to your question might have been or why the court is not able to answer a particular question. Finally, please be sure to keep the original question and response. Do not destroy them, as they are part of the official record in this case and must be returned to me when you return the instructions and verdict forms at the end of the case. Ladies and gentlemen, I will have a final concluding instruction to read to you at the end of closing arguments. The state may deliver their closing argument at this time.
Sorry if I turn this.
Yes, you may.
Good afternoon. I want to address a couple of preliminary matters before we begin the closing argument. First of all, I think it's appropriate to thank you all for your attention over the last 2.5 weeks. I know that the process can be frustrating, it can be lengthy, but we're deeply appreciative of your service and your ability to, shall we say, roll with the punches. I also want to address something too. Unfortunately, Detective Burrows had to go back to California yesterday for some other commitments, and that's why he's not joining us at the table. But I thought it was important for you to know that. I want to start off by refocusing our attention in this case, because this case is a trial about Christopher Dickerson. You didn't hear much about him because it kind of devolved into this sideshow toxic relationship between the defendant and Miss Varela. But it's not about that. We need to bring him back into this because Christopher Dickerson's life ended tragically, violently, and intentionally at the hands of this defendant, Stacy Rodriguez, in the early morning hours of October 3rd, 2021. It's about her murdering Christopher in his own home, stealing his property, returning to the house to burn it down, in the process destroying the evidence. I know it seems like a long time ago, but I want to talk back when we did the jury selection process, if you remember that. We talked about 2 parts to a crime, right? Remember that? Actus reus, mens rea. The actus reus, the act, mens rea, the mental state needed to perform that act. But we also discussed the topic or concept of motive, right? We have to prove the who and the what. We don't have to prove the why. That's motive, right? You can consider all the facts in determining that. Sometimes we don't know what the motive is. I think in this case it's pretty clear, and we'll discuss that as we move along. The law doesn't distinguish between that. You ultimately are the ones to determine what weight to give that particular evidence. But in the defendant's own words, with that in mind, remember, she admitted to the act of killing Christopher Dickerson. She admitted having the mental state of with intent and intentionally of killing Christopher Dickerson. But she qualified that. She qualified that because it was in self-defense. But remember, self-defense is a conscious action, kind of a confession and avoidance. I did it, but, right? Now, you sat here for the last couple of weeks. You heard a lot of individuals. You heard a lot of testimony. You saw a significant number of exhibits, right? But who didn't you hear from? You didn't hear from Christopher Dickerson. You didn't hear from Christopher Dickerson because the defendant murdered him. Now, it's easy to sit there and attribute statements to somebody that can't come in and defend themselves. In other words, you can say anything you want. You can admit what you can't deny, deny what you can't admit. But actually, in a roundabout way, you actually did hear from Mr. Dickerson. You heard that on that weekend of October 1st through October 3rd, he was happy. He had some friends visit him from out of state. Job prospects looked good. He had a house. He had his animals. He had finances. He had things saved up. Life looked pretty good until he met this defendant, Miss Varela. You saw him interact in the late evening hours of October 2nd and the early morning hours of October 3rd. You saw him leave his house. You saw him go downtown to Greeley. You saw his interactions in various establishments. You were able to track his movements as he went through there. You were able to see the point where the convergence happened, where he fatefully met this defendant. Goes back to his house. He saw that with the defendant, Miss Varela. You know he met a friend, Dolores, downtown. He leaves his house to go pick her up, to take care of that. He comes back to the house with the defendant, Miss Varela. You note that watching the house, you can see that from the video surveillance. You know they're inside. They come out at some point for a smoke break. You get to watch him. He's telling you what they were doing, right? At some point, though, you see one person leave, Miss Varela, get in the Chevy Malibu. And then minutes later, you see another individual, the defendant, come walking out. We know through the course of the investigation that Christopher's telling you he's dead now. He was killed and murdered by the defendant. You know through the course of the investigation that no 911 was used at that time, no reporting to authorities. You know that these two individuals, the defendant, Ms. Varela, left, traveled a little bit, came back to the house. How do you know that? Because Christopher's cell phone is telling you that. You know he's dead. His cell phone came out of the house. 3 went in, 2 come out. They come back to the house, still no call to law enforcement or authorities, still no reporting this. Ms. Varela stays in the car. The defendant walks back up there, enters the house, in there for a few minutes, and then you see the bright glow in Christopher's house. You know she set the fire. You see her leave. No sense of urgency, no running, no hurry. Gets back in the car and it takes off. And Christopher is telling you where they're going. They're driving back and around. They're going to Ms. Varela's grandmother's for a few minutes. They're going up to the defendant's residence for a few minutes. They switch cars, which we'll get to in a few minutes. And then all of a sudden his phone stops and he stops talking. Or so we thought, right? Because you also heard through Christopher from Dr. Burson, the pathologist. The not 1, not 2, not 3 or 4, but 5 significant stab wounds in his neck, closely grouped, with the weapon plunged forcefully into his neck and still there. I want to refer you to, and we can just look at it, instruction number 7, right? That's the credibility instruction. Everybody have copies, right? Okay, that's number 7, that's the credibility instruction, right? And boy, has this case been about credibility. Would you agree? When we spoke in jury selection, every one of you agreed to assessing the credibility of the witnesses. Not 1 or 2, not a few here, not a few there, all of them. And because of the nature that this case was presented to you in the jury selection process, you knew it was going to be self-defense. In that end, the defendant took the stand. As such, with that instruction, you as well put her credibility, she puts her credibility issue for you to weigh as well. And frankly, you can certainly look at how bad the defendant testified on the stand. It simply cannot be overlooked when you take into consideration the totality of this case and all the information you were presented with in the last couple of weeks. You know, Detective Blair with the Greeley Police Department, I don't know if you recall his testimony from about a week or so, or a week and a half or so ago. He was there at the scene of Christopher's house processing the area after the fire, after the fire department had put the flames out. And at one point in his testimony, he said, in an arson scene, nothing is as it appears to be. And ladies and gentlemen, that's exactly the same thing with the defendant's testimony in this particular case. It was scripted, it was rehearsed. When it got off track, it was brought back on track. Admit what you can't deny, deny what you can't admit. Ultimately, at the end of the day, you're the judges of witness credibility. You're the ones to determine if the investigation was thorough and extensive and complete. You're the ones that have to weigh the facts and evidence, and you're the ones to determine whether or not the prosecution has proven beyond a reasonable doubt to your satisfaction each and every element of the crime. So I want to start there. Let's kind of start with what the defendant wants you to believe about a few things. We're going to start with Mr. Dickerson. Now, they did everything they could to denigrate him, knowing that there was zero opportunity for him to get up and support himself or defend himself, if you will, basically attacking his credibility. They wanted you to believe that on that particular evening, morning hours, Mr. Dickerson was kind of on the prowl, right? He was out on the hunt. And they tried to support that through the friend of his, Mr. Mistall, because of some text message that he sent back, said it essentially ended up going out to the bars, grinding on thoughts. All right. Apparently that's a derogatory term, if we didn't know that. But when you look at the evidence that's been presented to you, what do you see? You saw a significant number of pictures of Mr. Dickerson, what? Alone most of the night, walking to and from bars, just basically kind of hanging out, trying to have a good time. Meets Dolores Vigil, her friends. You saw videos from Cubetas, from Miss Flores and Miss Carrasco, right? Just kind of spanning the crowd. Music's playing, people are dancing. There's Mr. Dickerson. He's not grinding on thoughts. He's not causing trouble. His demeanor is just hanging out. Nothing in any of that evidence from the time he went downtown until the convergence of events when he met the defendant, Ms. Varela, are indicative of him on the hunt or on the prowl. The bar's closed and he's walking back to his car. You saw that. You saw those pictures. He's walking to his car when he's confronted by the defendant and Ms. Varela in that Malibu. And they ask him about, you know of any after parties? His response essentially is, no, but I have drinks at my house if you want to come over. No wild celebration, no hell yeah, you know, let's burn the house down, burn the town down, anything like that. Sure, you want to come over? I got a few drinks. And we'll get back to some other aspects, where the defendant said, oh, he wanted to get into my car, but I didn't feel comfortable with that. Not sure how many people would simply hop in the car of a stranger and leave their car downtown and have to come back the next day, but certainly something for your consideration. It's also important to note that the defendant said through her lengthy testimony that the first cause of tension between the defendant and Mr. Dickerson was at Mr. Dickerson's home where they're playing music on the computer. And he asked her, or she asked him if she could play a song, and she played a Spanish song. And indicated to you, completely uncorroborated, that she played this song and he got a little indignant, questioning that type of music, upset maybe that type of music was playing, right? Made some inappropriate comments. Again, you can make up whatever you want to say about Mr. Dickerson because he's not here. But go back to what we had just talked about. He's downtown. He goes to this, because you got video from the Cubetas place, right, of those two. What are they doing? They're playing Spanish music. There's people dancing, men and women dancing. And he's just kind of standing there, listening, taking it all in. He's not throwing his hands in the air, not screaming, what kind of music is this? Nothing like that. Nothing about that statement makes any sense at all. Goes to Cubetas and hangs out there with that. He goes to Roasties, meets up with Miss Vigil and her friends, brings the defendant and Miss Hosanna back to his residence. All through that, there's no violence, there's no ill demeanor. He's just out trying to have fun. In fact, to his credit, at 2:49 in the morning, he's at his house when he gets the phone calls from Dolores. We know that happened. Phone records backed it up. All the evidence backs it up. And she needs help. Now, does he throw a fit? Does he say, absolutely not? No. He says, I got to go pick her up. I got to go help her. They go down and do that and drop her off and come back to the house. No indication at all about violence or a bad demeanor. As a matter of fact, Ms. Varela told you on the stand, both on the stand and at her proffer with Mr. Burroughs back in June of 2002, that he wasn't upset, he wasn't violent, he wasn't hostile. Mr. Mistel, the defense witness, also indicated that in regards to his demeanor, he was excited to see his friends, seemed in good spirits. They hung out for a while. I had no idea there was a show called Squidbillies, but maybe there is. All right, they watched that. Mr. Dickerson doesn't charge him for staying at his house, doesn't make him pay. They have a fun weekend. Mr. Mistel and his friend go on their way, and good enough relationship that they kept in touch, and he noticed nothing unusual about it. There's nothing to that point at all in this case that indicates Mr. Dickerson was the initial aggressor. They want you to believe that the the victim was so drunk, therefore he had to be violent. Yeah, all right. Yes, Dr. Burson testified that his blood alcohol level was a 0.36, right? He was. He was incredibly intoxicated that night. But doesn't that lend to the credibility of Ms. Varela as to what she told you? Perhaps the victim getting set up, right? Because what makes the most sense using your reason and common sense about this? You look what Ms. Varela says, the ride back from Dolores, dropping off Dolores, a decision is made, the defendant pours the drinks, right? Well, the defendant testified to that too. So, well, yeah, beginning, Mr. Dickerson was, then Hosanna was, but then I ended up pouring drinks as well, right? This is not self-defense. Don't get lost in that. This is plain and simple first-degree murder. And when you look at the sequence of events that particular night, this was not hasty or impulsive. There was reflection, there was judgment, reflection on the ride home, the decision to kill Mr. Dickerson, plying him with alcohol. We heard testimony that he's 6'2", maybe 180 pounds, right? What better way to take advantage of somebody than to get them drunk so you can steal their stuff? You know, you look at intent and deliberation as well when you go back to that. What about after the first stab wound? Or the second? The third? The fourth? And the fifth? With such force that you break the handle off and leave it almost penetrating his neck? They want you to believe that Ms. Varela is absolutely the most or uncredible person ever, right? We had several days of testimony of Ms. Varela. Again, using your reason and common sense, when you remember and you go back and you deliberate about all the things that were testified to, right? If in fact this was self-defense, why wouldn't she get on the stand and say, absolutely, it was self-defense? I was in fear for my life, the defendant was in fear for hers, or she was protecting me, or anything like that. Why not come in and say it? There's nothing about that that makes sense. And why lie about it, take a plea deal, which we're going to discuss, and get sentenced in this courthouse to 32 years in the Department of Corrections, if it truly was self-defense? It's because it wasn't. One of the, again, many things the defendant testified to is that she said Ms. Varela was in control of this. And after she murdered Mr. Dickerson, she told you that Hosanna Varela stated, hey, we got to look for cameras inside the house. I mean, seriously? What? Does that make sense? Why would you go and look for cameras inside the house to destroy potential valuable evidence that would support your claim of self-defense? Wouldn't you want to see if there's cameras in the house and then immediately call the police and say, hey, there's cameras in here, this was self-defense, as to what happened? They didn't do that because that didn't happen, all right? You know, one of the other things to consider too is that Mr. Burroughs' investigation was independent of what Ms. Varela told him several months after in her proffer. But not satisfied with that, you then hear from a defense expert who they hired and paid to come up here, a Boulder criminal defense attorney coming to Weld County, to tell you that the way this whole proffer thing went down, that mighty shady. The attorneys that would do that would be incompetent. And if you recall in her testimony, she was a blind expert. She had no facts, no circumstances, no context. Agreed. No two cases are the same. And yet tried to convince you that proffers everywhere should be the same as here. And if you remember the line of questioning, and I'll be brief here, I asked her would you buy a house sight unseen? She said, absolutely not. Would you buy a car sight unseen? No. Okay, then why should a prosecutor buy something, i.e. Ms. Varela's testimony, without hearing it first before you decide how you're going to handle the resolution of the case? She agreed. And of all the experts they could have brought here for you, they hired and paid for an attorney who doesn't practice in Weld County. And when told about the fact that one of Ms. Varela's attorneys was this Keith Coleman, that she knew very well, she admitted that, well, Weld County doesn't do proffers like everywhere else. And that's reflected in the proffer letter. You'll have that back there when you get to go back and look at the evidence, right? She admitted that it was a pretty standard letter and that Weld County is different than other jurisdictions in regards to proffers. Let's talk about Detective Burroughs' investigation, right? Again, you're the ones who determine if it was thorough or not. I want you to, if you have it, I believe you should have a copy of 223, Exhibit 223. That's the timeline, okay? It's a tool, right? Yes, it's entered into evidence, but it's not necessarily a piece of evidence, but it's a tool for you to follow along when you go into your deliberations as to what Detective Burroughs did, right? Well, initially we talked about that, the video surveillance, downtown neighborhood, right? Eventually he gets Mr. Dickerson's Google location, so he's able to overlay that on top of that. Then eventually he gets Ms. Varela's phone records. He's able to overlay on top of that and present to you this timeline for you to follow around, for you to determine whether or not this was effective investigation or thorough investigation or not. I would submit to you that absolutely it was. Sure, you're going to get up here. I'm sure once I sit down, you're going to hear, oh, they could have tested this. They could have tested that. They should have done this. They should have done that. A beer bottle that's out in the garbage far from the house, when really the defendant said that, and we'll get to that too, she chucked a beer bottle and missed, but it landed on the couch. So maybe after murdering Mr. Dickerson, she took the time to tidy up a little bit before they went to the gas station, returned to burn the house down. It just doesn't make sense, okay? It doesn't make sense in that regard. So, Ms. Varela tells you that the defendant intended to kill Mr. Dickerson on the ride back, okay? That plan goes into effect as soon as they get in the house because, again, she tells you, Ms. Varela, the defendant tells you that she started pouring the drinks. Mr. Dickerson's got a high BAC, right? It's corroborated by what Ms. Varela says and what the defendant says when they talk about giving him full glasses. And theirs were either a little bit or watered down or just straight water. What better way to incapacitate somebody bigger than you so that you can take from them? Now, this is where it gets different. At some point during the night, you recall the video clip of Mr. Dickerson going outside, right? They're smoking a little bit, then they go back in the house. And I think his dog, or he stumbles back in the house, right? So something happens. The defendant wants you to believe it's because she played some kind of Spanish music and then out of nowhere was confronted with this file, this metal weapon, and they get into an argument about manhood and et cetera, right? Ms. Varela says she noticed that there was an argument. Mr. Dickerson is standing next to or over the defendant, not hands on her, right? The defendant pushes him back. I mean, the defense expert, Ms. Herford, talked about coordination and balance when you're that intoxicated. He falls to the ground, and she gets the beer bottle. But let's back up just a little bit, right? Ms. Varela tells you, before all that, that in the house, she notices this file. Thinks it's a little weird, covers it up, no big deal. Points it out to the defendant. Okay? The defendant tells you that Mr. Dickerson, who you don't get to hear from, went back into his room and brought it out and then apparently showed him, right? Convergence of events, divergence in the house, and then another convergence. So let's talk about that in the house for a minute, right? Because Ms. Varela tells you that the defendant pushes Mr. Dickerson back to the point where he stumbles back. Ms. Varela tells you at that point, like any person probably would, he's screaming at them to get out of the house, get out of my house. Not satisfied with that, the defendant grabs a bottle, apparently throws it and misses, and then either has the same bottle or another bottle, cracks Mr. Dickerson on the head, and cracks him with another one. The defendant tells you, oh, I didn't see any blood that night. Varela tells you that he was bleeding profusely from the face, was incapacitated, maybe even unconscious at that point. Could be a combination of the alcohol, could be a combination of getting hit in the head by the defendant with a beer bottle. But there's blood, right? Remember the line of questioning of Dr. Burson, well, you didn't notice any injuries on his head or cuts or anything like that. You saw the autopsy photos, okay? He was burned beyond recognition. They had to determine his identity through dental records. Defendant tells Ms. Varela, yeah, we got to go back and burn the house because it's harder to identify a body. Keep in mind, too, right, that Ms. Varela had, well, you heard discovery, right? She only had up to sub 65. A lot of this information came after the fact. The defendant has had the benefit of sitting here, through this, and, well, benefit of reading all the discovery, looking at all the videos, anything you could think of, benefit of sitting here in trial, listening to all the witnesses, and then culminating with her getting on the stand to make sure that her story fits. Her scripted, rehearsed story fits. Varela tells you at that point, the defendant is over Mr. Dickerson on the couch, using her weight, hold him down, and looks at her and says, go get that thing. And she does. She admitted to that, right? And comes back, and the defendant starts plunging it into Mr. Dickerson's neck. Now, you saw the photos. You saw the grouping of the wounds, right? Not one, not two, not three or four, but five. All within, if I'm recalling correctly, Dr. Burson said within a 2-centimeter area. The defendant wants you to believe that in this particular case, this struggle is going on. And during this time, Ms. Varela just kind of appears with this, and while this struggle is going on, she's not sure if Ms. Varela is going to give the weapon to Christopher or to the defendant. Then somehow this struggle ensues, and Christopher ends up with the weapon, and the fight's on, and the rolling, and she's hitting his hand on the carpet, reaching for a beer bottle, doing the layup throw, misses him, and then comes into possession of the weapon, isn't looking at him, isn't looking at Ms. Varela, and doing this motion with her tricep back at him. Okay. Dr. Arson testified as to the force necessary to inflict the wounds on Christopher's neck using that weapon, that blunt end. It wasn't sharp. The blunt end, the flat end is sticking out. I mean, as opposed to a blade, flat end is sticking out. You're not going to be able to do that type of penetration by doing this and not looking and grouping it like you did and causing the significant damage and carnage that you did. Okay? I submit to you that based upon the totality of the facts and the circumstances that Chris was incapacitated. Varela says he's laying on the couch with his neck exposed. This defendant came up with the force necessary, again, not 1, 2, 3, or 5, but 4, but 5 times, and left it in his neck. By all means, take a look at that exhibit when you go back. Look at the end of it. Determine for yourself if that is something that could just go penetrate 5 times going up like that. It didn't happen the way the defendant said that. Afterwards, right? Again, the progression, together, diverge, back together again. They get in the car, they go back, they come back, they burn the house down. Defendant wants you to believe it's because she's kind of in some kind of stupor. Varela admits that she was drunk that night. It's funny, the defendant, in a sense, admitted that too, but boy, crystal clear on every little minor detail, right? Credibility, that's something for you to consider in going back to that. But keep in mind that after they do this, right, they walk into his room. You saw the pictures from the fire. All of his things are on the bed, right? Ms. Varela is apparently not doing well for Ms. Rodriguez. She tells him to go out, and she came in here and gave you a description, okay, of what she saw. You're the judges of the credibility, but she came in and told you that there was blood everywhere and that he was gurgling. And she didn't know what to do, and she saw him take her last breath. Again, if it's self-defense, ladies and gentlemen, why come up with that? Why come up with that elaborate, we'll call it elaborate story, right? They steal his property, they leave, they come back, they burn the house down, they destroy evidence, they destroy Christopher. Admit what you can't deny, deny what you can't admit. I want to talk a little bit about the jury instructions, if you kindly follow along. You note that instruction number 3 is what the defense contends. They admit that she's guilty of the arson, where she burned the body of Mr. Dickerson, so fine. She also contends she's guilty of tampering. That necessarily means she's guilty of the burglary in regards to the arson. We've talked about credibility, but I want to go back to the elements, and I want to start on page, it's instruction number 14, okay? The defendant, Stacy Rodriguez, in the state of Colorado, at or about the date and place charged. After deliberation with intent to cause the death of another person, caused the death of Mr. Dickerson without not legally authorized by the affirmative defenses as noted in 16, 17, and 20. So, in jury selection, we talked a little bit about this too, right? I mean, the burden of proof never moves from that table, right? It's always upon the prosecution, no matter what. Right? It never shifts, okay? In addition to proving you beyond a reasonable doubt, we also have to disprove. These affirmative defenses is what they're called. So we have to disprove self-defense. And I would submit to you, ladies and gentlemen, that based upon all you've been presented with, the testimony, the evidence, the videos, the things you've seen, Mr. Dickerson wasn't the initial aggressor that night. The initial aggressor was this defendant right here. Deliberation took place on the car ride home from Dolores. She executed Mr. Dickerson in his home after plying him with alcohol. She took advantage of him, she killed him, and she stole from him, she burned his house down. Never bothered to report it. Never called 911. In summation, for my first part. When you go back there, there's a lot of things to look at, and I know that, right? I know that. I think it's important to look at the body-worn camera of Detective Burrows with Hosanna Varela on November 11th, 2021. Look at her demeanor. Look at her eyes, okay? Look at her lip, trembling, right? The change in her demeanor when told what she was being charged with, right? Did that look like somebody who was in control of the situation? You contrast that with the defendant's body-worn camera of Detective Hunziker, which I know you've seen a lot of times, but I think it's important, right? During that interaction, confronted with a picture of Christopher. Nope, never seen him. You ever been to 2413 15th Avenue Court? Is that a business? No, it's a house. Oh, no, never been there. Okay. You ever been down to Cavetta's? Yeah, been down there a few times. All right. Ever ran into him down there? No. Were you too drunk to remember that night? No, I wasn't. Okay. And then during that course, in the Tahoe, she tells you, or she asked Detective Hunziker, hey, what is Hosanna saying? What are they saying? Denies on the stand that she can see this. When obviously she's clearly looking through the car and can see what's going on. Hey, what are they saying? And Detective Hunziker says, I can't hear. I can't hear. And then ultimately, well, we heard this testimony about social anxiety and, I, for lack of a better term, an emotional support battery. That makes no sense. She talks about going to the bars, hanging out with people, doesn't know what a dartboard is, but they're always looking for an after party, either a known or unknown homes. Social anxiety, that's the excuse. But she had a battery in her hand, so that must have helped. But ultimately, when advised by Detective Burrows what she's being charged with, there was no hesitation. Really? Do you have proof of that? Yes. Yes. Yes, we have proof of that. You heard it. You saw it. This isn't self-defense. This wasn't done in a hasty and impulsive manner. Ladies and gentlemen, this was intentional. This defendant is guilty, and we ask you to return verdicts of the same. Thank you.
All right, thank you. The defense may give their closing argument at this time.
Thank you.
Oh, I'm sorry. Can the parties approach? All right, ladies and gentlemen, we're going to take a quick break before we begin with the defense closing argument. Give me just a second here. Sorry, give me just a moment. Ladies and gentlemen, I want to remind you that until the trial is completed, you must not discuss this case with anyone, either in person, using the internet, or by any other means. This includes members of your family, people involved in the trial, other jurors, or anyone else. If someone approaches you and tries to discuss the trial with you, or if you see or hear anything about it, even accidentally, please let me know about it immediately. You must not conduct any research, undertake any investigation, or otherwise obtain information about the case from an outside source. You must not read or listen to any news reports or internet information or other electronic sources about the trial. If there has been or is any news coverage of this case, you must completely disregard it. Your verdict must be based solely on the evidence presented in the courtroom and the laws I instruct you. And finally, it is especially important that you do not form or express any opinion on the case until your deliberations at the end of trial. With that, we'll be in recess for 10 minutes. Please rise for the jury. All right, please be seated. Court will be in recess for 10 minutes.
Right? That's what you're being charged with. Stacy's being charged with that as well too. If you want to talk to me, I'll talk to you about it, and I can understand what happened that night. Okay? It's only if you want to. You don't have to. If you want to talk to me, I'll. You're under arrest for first degree.
I'm gonna unplug it though for now because I hear static.
Okay.
No, honestly, he's underestimating how much, how long the duration should take.
Yeah, I think he was a little bit.
We're gonna see whose voice breaks first.
What's that?
We're gonna see whose voice breaks first, between you and I.
Oh, yeah.
Who? Oh, Evie. How's Evie doing? Oh, were they here earlier?
I'm so like caught off guard. What? So Judge, on these sort of archive VHS records, do you, typically we don't upload STV records.
Okay.
Do you want these?
If you don't, if you don't typically just keep them someplace.
Yes.
We just need them for the appellate record.
Yes, and I have it here. Did you see Friday?
Yeah, you got efforts in, John.
Like, these
ER 2296. The parties are present as previously captioned. We'll go ahead and bring the jury in and resume.
Please rise for the jury.
All right, thank you. Please be seated. Ms. Devereaux, you may begin.
Thank you. As we told you in the beginning, this case revolves around people making decisions and reactions under pressure. Before you got to meet Stacy, you were painted a picture of a predator in every sense of the word. In their opening, they called her a vicious and violent murderer, a person who randomly decides to kill a stranger while driving in a car where there was nothing but, quote, good vibes, who stabs a man 5 times and then looks, quote, glowing, quote, refreshed, and, quote, excited, before going back and getting and more and stabbing him more. A person who is so deranged that after stabbing someone to death, they lick their hands with their blood, the other person's blood, all over it, tasting another human's blood and saying, quote, his blood tastes dirty. A domestic violence batterer who hit their partner with a car 3 different times, held a knife to her throat, beat her, caused cuts all over her body, and who threatened her children's lives. A serial killer who killed 3 to 4 other people and then burned their bodies to get away with it. And now also a gang member in an unknown California gang. Someone who's really into fires and steals their murdered victims' belongings to just burn them later. And now a person who apparently lies under oath about having social anxiety. Ladies and gentlemen, I'm going to remind you about what Mr. Parelia told you in the beginning, about that quote he gave you. Let us take things as we find them. Let's not attempt to distort them as to what they are not. Every aspect of this case has been the prosecution attempting to distort who and what Stacy is as a person, to dehumanize her and make her into a vicious and violent murderer. It's much easier to get a conviction on first-degree murder if you distort who someone is and then you stand up here and yell about how evil they are. But you got to hear her. You got to hear from her. You got to see her. When Stacy described to you going to Hosanna's grandmother's house later in the morning of October 3rd, she described getting sick again. But this as a physical reaction to the trauma she had just lived through. She described going into her spare bedroom and not being able to sleep, just laying there, thinking about the nightmare that had just unfolded. And when asked, did you have any other kind of physical reaction that night to what happened? She said, no. I just wanted to be with my mom. I just wanted to be with my mom. Does that sound like a person to you who forms the intent and desire to take a stranger's life in the backseat of a car? Who plots to get him drunker as part of some sort of apparent overall scheme to get the physical overhand to make it easier to kill him for the purpose of stabbing him in the neck 5 times? Does that sound like a person who viciously and violently and unjustifiably murders someone? And does that sound like someone to you who later writes their brother and says they don't believe they can ever be happy again? Does a vicious and violent murderer turn to their older brother and say, quote, "I'm literally going through the hardest part of my life and I don't know if I want to keep going"? Does a vicious and violent murderer become so traumatized by what happened that before they're arrested, they describe not being able to sleep to their older brother because, quote, "every time I close my eyes, I see him"? No. No. During opening statements, the prosecution previewed Dr. Burson's testimony and argued that this was an intentional killing, first-degree murder, because each stab wound was in the neck region and all directed in a location where Stacy knew there were arteries. Remember that? Do not let them distort. Let us take things how we find them. She was a 19-year-old girl who had dropped out of high school as a freshman, 14 years old, to work and take care of her mother. She doesn't even have a GED. And you saw her and you heard her. When asked whether the night at the Clarion was a noteworthy moment in her relationship with Hosanna, she said, "I don't know what that word means." She didn't know what the word noteworthy meant. When asked if she knew the basic idea or concept behind fight or flight, no. That's not someone who knows what an artery is, let alone plotting to get this guy drunk and pick the precise anatomical location where she knew it would cause a massive bleeding and ultimate death. That's not what we have here, folks. Instead, the location of each stab wound, the weapon that was used, how the weapon was used and left behind, is all consistent with a fast, unplanned, and instinctive action. Now, as we all know, first-degree murder is the most serious crime anyone in this state can be accused of. As it should, a conviction of first-degree murder demands that the prosecution be able to prove beyond a reasonable doubt not only that the person was killed, not only that there was specific intent to kill, but also the added layer and that killing came also after deliberation. After deliberation, it's not up for interpretation. That definition about what the law tells you they have to prove is in your jury instructions. And it's not any less of an element than the fact that someone died here. Every element weighs the same. And the term after deliberation means that they have to prove Stacy decided to kill Mr. Dickerson after the exercise of reflection and judgment. The law tells you this cannot be a quick, momentary, one thought after another type of thing. In fact, the law prohibits a conviction for first-degree murder if it was committed in a hasty or impulsive manner. Think about what those words mean. Think about the synonyms for those words. Hasty, speedy, hurried, rushed. Think about these synonyms for impulsive, spontaneous, instinctive, unthinking, reflex, knee-jerk. Every single aspect of this case, every single piece of physical evidence concerning Mr. Dickerson's death tells you beyond all doubt that this was quick and it was hasty. And that it was an instinctive response to the imminent threat that Stacy was facing. An instinctive response to save herself. Take this metal shiv. This is not a traditional weapon. This isn't her bringing a weapon to this guy's house to plot and plan, to feed him alcohol, to take advantage of him, to get him drunk. This isn't hers. And make no mistake, if Hosanna Varela had the ability to tell you or show you that she had seen Miss Rodriguez with that thing before, or if they could have done that, they would have. If the prosecution had the ability to bring in a single witness who could tell you that they knew that Stacy had that item or a similar item, or if they found a Facebook picture or a conversation that had anything to do about a shiv or a weapon like that, you all would have heard that and seen that. Nor did Stacy introduce that metal shiv at the moment things escalated and Mr. Dickerson got physical. Even Hosanna had to admit, albeit with a completely different version, that she was the one who introduced that shiv and the point where things were escalated and conflict was ensuing. And notice how she minimized her culpability, right? When admitting that. Oh, Stacy directed me. Stacy told me to go get it. The reality is that she is the one who introduced that weapon into the situation. And when Mr. Dickerson grabbed the metal shiv while being over Stacy, not letting go while she is pleading with him, it all happened so fast. And as we discussed way back in jury and selection, and these types of moments, they aren't planned out. No one plans for this very moment. She had split seconds to react. There was no appreciable amount of time to exercise careful reflection and judgment. There wasn't. She told you, quote, he grabs it, and then I'm obviously trying my hardest to just leave. She described using both hands on his one hand that held that metal shiv. I kept hitting his hands on the floor so he could let it go. I wasn't strong enough to get it out of his hand with the one, but I was just trying to hit it out of his hands. Both of her hands on his one. And in those split seconds, when she breaks free from his grasp, he pushed her in the face, consistently trying to grab at her. And she instinctively fought back. Again, there was no time, no appreciable time for reflection and judgment. It cannot be one thought after another. It was hasty and it was fast. It was impulsive and it was instinctive. It had to be. She told you in your own words, were you looking at him? No, I wasn't. I wasn't looking while I was doing it. At that moment, I didn't think anything, and then he was still continuing to grab me. So I kept kicking him and I sat up, and that's when it happened again and it broke. Quote, I didn't know that I'd hit him. I didn't even know that she didn't even know that she had made contact until reviewing discovery and saw that she did it 5 times. She wasn't looking at his direction. She was too focused on trying to get away. So when they're questioning her yesterday, what were you looking at? Of course she's not going to be able to tell you. Her only thought in that moment was self-preservation. Stacy described falling when she was trying to get up as they were fighting over the shiv and it breaking, which is consistent with Dr. Burson's testimony that he believed the metal shiv had a handle that had been broken off. Again, every single aspect, every single piece of physical evidence concerning Mr. Dickerson's death tells you beyond all doubt that it was hasty and quick, that it was instinctive, and an instinctive response to an immediate threat. What deliberate, intentional, and premeditated murderer leaves the weapon behind in the body? She went through all of this to try and escape, apparently getting caught and planning this murder and feeding him full of drinks. Why would she leave that in his body? Dr. Burson, with over 14 years of experience, the Weld County coroner, who has conducted thousands of autopsies, told you he has never had a case where a knife or a metal object was left in the body. Why? Because you don't intentionally kill someone unless you want to get caught and leave behind the weapon. If you go through the trouble of burning a house down to avoid getting caught for intentionally killing someone else after deliberation, after time to allow for exercise of judgment and reflection, you don't leave it behind. Now, the part of the metal shiv that was used also corroborates what Stacy told you. The prosecution wants you to believe that Mr. Dickerson was vulnerable, that this was a vicious, violent attack on an unconscious and vulnerable person. But then they also want you to believe Hosanna Varela, right? They want you to believe Hosanna Varela, who told Mr. Burrows through her proffer that after Mr. Dickerson was hit in the head with the bottle, he had blood in his eyes, fear in his eyes, and yelled at them to get out of his house. So if they want you to believe Hosanna, he wasn't unconscious. But if true, Mr. Dickerson was knocked unconscious between the high BAC and the bottle smashed on his head, why wouldn't you use the sharp end? If the prosecution just stood here and told you that he was laying unconscious on the couch with his neck vulnerable, why would she use the blunt end? Why would she risk that injury to herself? If her goal and her entire purpose for all of this was to kill him, you don't use the blunt end. Stacy had to use the blunt end. And she had to because it wasn't intentional. This wasn't a decision made after careful reflection and judgment. He had the metal shiv in his hands. We know that. So when she was finally able to grab it from him, again, this is the sharp part of the pen, the pink part. That's the sharp part. We know he had it in his hands because otherwise, she grabbed it from him and had the blunt end. When she was finally able to grab it from him, it meant that the sharp end that was the threat to her landed in her palms. And she didn't even have a split second to flip it over before she had to use it. Doesn't get any hastier. It just doesn't. It doesn't get any more impulsive, and it doesn't get any more instinctive. This was an instinctive response to an imminent threat of Mr. Dickerson being on top of her, of not letting her go, pushing her, and having that weapon in his hands and in her face. She didn't even have the split second. Flip it over. And the wounds that Dr. Burson saw are also evidence of this and are consistent with Stacy's testimony. Dr. Burson testified that all 5 wounds were in close proximity of each other, less than 1 inch. That to him, that means that all 5 wounds were done in, quote, rapid succession and in a short period of time. Rapid, hasty, not first-degree murder. Dr. Burson described 4 of the stab wounds being in the front area, around the Adam's apple, and being from front to back. And the last one, the one with the shiv still in it, being in a slightly different location that also had a movement path of front to back, but also slightly right to left. During cross-examination of Ms. Rodriguez, the prosecution used the analogy of a dartboard and said, well, what are the odds that you could hit the same exact spot while not looking? Well, ladies and gentlemen, difference being, you're not standing a few inches, a mere inch or 2 from a dartboard. A dartboard is not grabbing you. The front to back aspect of those 4 stab wounds are consistent with Stacy's description of the close proximity of their physical struggle. Him in her face with this weapon, him on top of her. And that last wound being consistent with Stacy describing not knowing that she had hit him until the object broke because he's grabbing at her. The right to left nature of that last wound is consistent with him moving his head to the left as he's pushing forward, trying to get her. There was no evidence that Mr. Dickerson, in light of those 4 stab wounds, would have not been able to be a threat to Stacy. Still grabbing at her. Instead, the only evidence you all heard was the exact opposite. Dr. Burson testified that Mr. Dickerson would not have been immediately incapacitated. Sarah Erfer, the toxicologist, explained that the other scientific explanation behind Mr. Dickerson's ability to keep moving, keep grabbing, still being a threat. She explained that alcohol has an analgesic effect, a pain-killing effect. Alcohol impacts a person's ability to perceive pain. She explained to you that science tells us that as a person's alcohol consumption and BAC increases, so does that affect on their pain tolerance. And in that moment when the metal shiv broke and Stacy realized that she had made contact with him, she explained to you that Mr. Dickerson was no longer moving. Remember, she described scooting back, sitting there, just looking at her hand, frozen. She didn't intend for any of this to happen. Why would she? And while the prosecution doesn't need to prove motive, they don't. They still have to convince you beyond a reasonable doubt that it was her conscious objective to kill him that night. Why? Why would she do that? Why do you kill a random stranger? For what? And notice their theory just keeps changing, right? It's because at first she's irately jealous that Chris had the audacity to ask Hosanna where she worked and not her. But then it turns into on the way back from the car, according to Hosanna Varela, she just decided to randomly kill someone when they're all having good vibes listening to the music. And then it changes again to this like weird intent to rob, right? Well, that doesn't make sense either, because if you go through all this trouble to poison this guy, to get him weak, to rob him, why do you not take the laptop sitting in the living room that you heard was found burnt and melted to a backpack? Why don't you take any of the 8 other gift cards in his wallet? Why don't you take a dime from his bank account that has 43 grand sitting in it? Why do you take what you take and then just burn it if you believe Hosanna Varela? None of this is true. It's all made up. None of it is true. And why would she want to do this? You heard her talking to her brother afterwards as part of a Facebook message, telling him that she just missed her old life and her happiness that she had before Hosanna, before October 3rd. Why would she choose this, any of this? Or is it more logical that none of this was planned? Is it more logical that none of this was wanted, and instead this was hasty and impulsive, an instinctual response to an imminent threat that she was facing? And as we talked about back in jury selection many, many times, it's the totality of the circumstances, right? How many times back then did we talk about how I wish you could have had all the facts, and as we're posing these hypotheticals, right? Now you have all them. And it's the totality of those facts and those circumstances that you have to consider in leading up to that split-second decision that she had to make. Consider, she's at a complete stranger's house in the middle of the night when the rest of the world sleeps. The complete stranger is a man who is nearly double her age. That complete stranger is a man who's nearly a foot taller than she is. A complete stranger who is clearly intoxicated, who lied to them about having an after party or having a roommate be present and clearly was not as the night progressed, who chose to wear a shirt out that evening that read, quote, straight out of fucks. Both Stacy and Hosanna described him as being touchy. Hosanna telling Mr. Burrows that he seemed off, seemed different, seemed weird. How many times did she tell Mr. Burrows during the proffer that she just wanted to go home, that she was uncomfortable? And of course that changes later in the proffer, and we'll get to that. You know, when she says, oh, actually, he was a nice guy. Like, that's not what they want to hear. They don't want to hear about how uncomfortable she was. And then this complete drunk stranger takes out this unusual weapon, something that looks like a prison shiv, to Miss Rodriguez.
Objection.
All right, and the objection?
Our prior records.
This
All
is already
right,
testified
can the
to.
parties approach?
Mr. Dickerson's state of mind going out that evening. He painted a rosy picture of him, you know, and good money in the bank, and, you know, he had some job interviews. Why are we completely ignoring the fact that everyone, neighbors, roommates, former coworkers, everyone knew this guy was pissed off that he had just gotten fired after months of a contentious relationship with his employer? And then at 36 years old, you go out by yourself to downtown bars in Greeley. You don't interact with anyone. You stand there watching people dancing at these clubs to the point that when the officers go back and they're like, hey, we're investigating this case, the person at Cubetta's is like, hey, I got a video for you because this guy stood out to me. It was weird. And when the prosecution tells you there's no evidence that he was the initial aggressor, that is not true. That is not true. That is blatantly false. By all accounts, he was the initial aggressor. When he stood over Miss Rodriguez, putting both hands over her, you don't have to touch someone. You do not have to touch someone to not be the initial aggressor. Or sorry, let me take that back. You do not have to touch someone and you can still be the initial aggressor. As we discussed in jury selection, who the initial aggressor is matters as to whether or not you get to stand your ground and take another's life to save your own. And by all accounts here, Chris Dickerson was the initial aggressor. That's completely undisputed. And imagine the fear pulsating as she felt his alcohol-infused breath. Remember her describing that to you? As she's physically trapped underneath him, unable to move, feeling the spit of his anger landing on her face. That's not something you forget. As he's yelling at her, "Did you call me a bitch?" And in that moment alone, she is justified in using self-defense. She did not have any duty to retreat. We talked about that over and over and over again during jury selection. She tried to, though. She tried to. She pushed him away. She tried to get out of that house. But when he grabbed at Hosanna, it escalated things. She described it escalating when she is trying to get away as he's grabbing at Hosanna and she's struggling to open the front door in that moment of panic and fear. When she tries to interfere with him grabbing at Hosanna, it enrages him again, and he shoved her onto the couch. Both hands. His body on top of hers, pinning her arms down, struggling, unable to leave. And at this moment, even before Hosanna interjects that metal shiv, Stacy told you that her only thought in that moment was, quote, "He's gonna fuck me up." And even at that moment, she is legally justified in using self-defense, drunk or not. And remember, the law of self-defense authorizes you to use deadly force to take another's life in a wide variety of potential situations with a variety of potential injuries. I'm not going to go through all the jury instructions, but read carefully instructions 16 through 25. 16 and 25 tells you that the law recognizes this need for self-preservation can be necessary under a host of different situations with a variety of different injuries. So look carefully at what constitute first and second degree assault, because you are legally justified in taking another person's life if you believe any one of those assaults could be happening to you. And look at first degree assault means intending to cause and causing serious bodily injury with a deadly weapon. Serious bodily injury includes a penetrating knife wound, risk of serious permanent disfigurement. Stab wound would certainly qualify for that, right? Then there's second degree assault, bodily injury with a deadly weapon. Stacy was without a doubt reasonable for believing she was going to, at a minimum, receive bodily injury. Bodily injury is a very specific definition. It's in your packet. Any kind of physical pain. Any any physical pain by that thing. Then there's second-degree assault reckless, which means at a minimum, when Mr. Dickerson grabbed that shiv in that moment of conflict and put it in her face, she had every reason to believe he recklessly could have caused her serious bodily injury. Permanent disfigurement, stab, the bare minimum. It is reasonable for her to think when that is in her face, he's on top of her, that he recklessly could give her serious bodily injury, at the very minimum. And then when he had that metal shiv in his hand, she doesn't just forget about everything that had just happened. She doesn't forget that he's bragging to her about using that thing to hurt other people. Again, she has only seconds to act. It was fast, and it was hasty, and it was instinctive. The degree of force was reasonable. What else was she going to do? You heard her. She wasn't intending to stab anyone. You heard that she wasn't even looking in his direction. Had Mr. Dickerson been stabbed 20, 50, 30 times, okay. But as she told you, she didn't even realize that it happened, that she had made contact until she fell and it broke. And then he stopped moving. And we want to talk about her credibility. Ladies and gentlemen, she could have gotten up there and told you all that she was stone cold sober, right? They don't have any evidence of anything opposite of that. They don't. She could have got up here and said, you know what, guys, I was completely sober. I didn't drink anything that night. But that's not what she did. She admitted to you that she was drinking to the point that she threw up a couple times. But common sense tells you when those things happen, when you're feeling someone else's spit and anger land on your face, you remember those moments, right? They don't have any problem with Hosanna Varela, right? Who was also intoxicated that night. They're not telling you, well, you know, yeah, Miss Varela is not that credible, right? That's not what they're saying. So why is it okay for Miss Varela to be intoxicated and yet be able to give you play-by-play details, but Stacy can't? Ladies and gentlemen, if the law does tell you that if you believe for a second, that Stacy's actions were not made after some appreciable length of time to allow for that deliberation, to allow for that reflection, to allow for that judgment, then it is your duty, your right, and your obligation to return a verdict of not guilty. And honestly, the only evidence that there was intent, that there was deliberation, there was time for reflection and judgment comes from the words of Hosanna Varela. That's it. You heard Mr. Burrows testify. They didn't have any evidence of what happened in that house. And during the judge's opening remarks to you and in those jury instructions as well, you were told, you all are the people and ultimate finders of fact and judges of credibility. You have to consider, as the judge told you, that it is your responsibility as jurors to decide what testimony to believe, and that decision should be made with a consideration of the motivation and the manner in which each witness might be affected by the verdict. Now, when Hosanna was arrested, We saw it. We've seen these videos multiple times. We know she wasn't planning it. We know that she was not planning on that Wednesday afternoon to being ripped from her kid's life. Just to be clear, no one at this table is saying, hey, jury, think Hosanna is a liar because she had the audacity to lie to her children about being on vacation. No. Any mom would do that. Any parent would do that. They're missing the point. We played those jail phone calls between Hosanna and her children so you could hear what she had to hear. You heard those children's voices. You heard her voice cracking in response. Mommy, when are you coming home? Those children's voices are gut-wrenching. And they're not even our kids, right? Imagine being in Hosanna's shoes and hearing that every single time you talk to your child. Your little ones. One's still in diaper. That would make, and the whole point of having you guys listen to that, was that would make any parent want to do anything that they could to get out of jail, probably just short of trying to dig their way through those cement blocks with their own bare fingers. Any parent in that situation would do exactly what Hosanna did. Anything and everything to get out of her situation and back to those kids. Imagine the desperate and unbearable amount of guilt and pain that she felt. And Javi, her sweetheart, he wasn't her high school sweetheart, certainly wasn't making it easier on her, right? When he's talking to her, he's saying things like, what do you want me to do if you fuck yourself? Giving her doses of reality. What if you don't come home? We can't tell the kids that you're on vacation forever. They're gonna figure it out. And then she hears about things like him taking their son for a haircut and him randomly saying, Mommy's not coming home. And ladies and gentlemen, she hears that days and weeks and months go by. She can't bond out. Reality is setting into her that she cannot fix this situation. Those court dates come and those court dates go. And she's in the jail on first-degree murder charges. Let's not lose sight of her being charged with it as well. And she also has this whole other added layer of misery, right? You heard that she wrote her sister on May 10th saying, quote, it's been hard. I feel like a damn animal. Like, this is inhumane. I literally cannot be around anyone, talk to anyone. When I come out of my cell, it's like walking into another cell. I can't even see the daylight. At this point, she's missed Christmas with her kids. She's missed birthdays. She missed her firstborn's kindergarten graduation. And she tells Javi in a letter saying, I missed all these milestones and him graduating kindergarten being one of them. And I'll never be able to have that memory with him. And on the other hand, she's also seen Discovery, don't forget. She knows that they have her dead to rights there at Mr. Dickerson's house. She knows that they have her on camera at minimum, right? Going into that house. She also knows that it's her fault, that she interjected that weapon. And honestly, heard she was drunk. She probably went to get it to help Stacy. Mr. Dickerson grabbed it because he probably thought the worst as well, right? But all Stacy knew was that she was pinned on the couch underneath this guy who had this in her face. And Hosanna is sitting in jail for 8 months with all of this weighing on her shoulders. And there's nothing she can do. She can't bond out until there is, right? And we don't know how this proffer came to be. We don't know who reached out to who, her attorneys or the prosecution. We know, though, that her sister Hannah was the one who initially explained to her this concept, this idea of giving information to the police to get time off her sentence. We also know that the guards reinforce that that is a real thing that happens. Sorry. And talk about using logic. If Hosanna did nothing wrong, right, then why did she wait until the proffer to share any of this information, right? And the reality is, she did it to benefit herself. And her level of desperation is clear as day from the drastic and illogical extremes she went through to paint Stacy as evil. Deciding to kill Mr. Dickerson randomly in the back of a car, well, otherwise there was good vibes. And you heard that wasn't even mentioned. She didn't even tell Mr. Burrows that during the initial 43 minutes of her narration of her proffer. It wasn't until after she went back and after she talked to her attorney for 30 minutes and she came back and said, oh, Mr. Burrows, in the middle of you asking me about how many times Mr. Dickerson slapped my butt, I just remembered that I'd asked her, at what point did you decide to kill this guy? And she was like, oh yeah, in the back of the car where I was listening to the music. That doesn't make any sense. She knew that they needed that information. You're telling me that her lawyers weren't like, hey, first-degree murder means X, Y, and Z. Of course they did. And then there's the bit about feeding Mr. Dickerson shots of vodka while taking shots of water. And although then she backtracked and said she didn't know if it was water, but just knew it didn't really taste like alcohol, so she assumed it was water. Water and vodka don't taste anything alike. You don't get those two things confused, right? Then there's this going back to wait in the kitchen, and like, as you saw the pictures, there's this little wall separating just a few feet away, and she's describing, hearing what she describes as bone and rubber, and then describing Stacy coming in, taking a break, and looking glowing, refreshed, and excited. And then there's the extreme about drinking another person's blood and saying, oh, his blood tasted dirty. Do you think that girl, that 19-year-old girl, is down there licking her hands after just killing this person saying, his blood tastes dirty? That did not happen. That is completely illogically made up. And then there's a bit about her describing catching Stacy dramatically staring at her own hands in the car, her blood-soaked hands, and then Hosanna playing it off as cool that Stacy had told her that she had killed 3 to 4 other people, and so cool that she told Stacy that she kind of knew. And Stacy responded, oh, really? And Hosanna said, yeah, well, yeah. Like one was telling the other that they didn't like each other's cooking. That didn't happen. And they know this is not true. They know it's not true. They know there's no other murders. There's no other murders. And I know they're going to come up here and say to you, well, it only matters that Hosanna believed it was true, right? Because that's why she didn't go to the police. But if that's true, then why on earth would Hosanna, a mother, allow Stacy near her children immediately afterwards? Why would she let her children pose with Stacy when they're trick-or-treating in downtown Greeley? Why would she tell her, hey, can you watch my kid? And then you saw that text message exchange. Any parent knows that that is just not based in reality. And if it had even an ounce of truth to it, just an ounce, then when she got those jail letters that they've told you about over and over again, that claim that Stacy wrote and that is threatening her children in it, that if she believed any of this for an ounce, and if it's true, then you know what you do. You go to those deputies in the jail and you say, my kids, their lives are at risk by this crazed serial killer who I just saw drinking blood from a stranger after she just murdered him. That's what you do. Or at the very least, if you don't trust police, right? You tell your legal team and they go to the police. And you heard her repeatedly tell you, well, I gave this information to my legal team. Then where's any of the police reports? Where's any of those officers who investigated this? Where's any action by her legal team to look into this? Because they knew it's not true. You make up these gross exaggerations because it's a lot easier to face and explain things to your children, to your family, and to the court when you come back for a reconsideration if you paint the other person as downright evil and yourself as a collateral victim. That's what she did. And those drastic and unreal extremes continued when she was confronted with the completely nonsensical and absurd response that she had to any of this that happened on October 3rd. First of all, it is patently absurd that you would watch someone kill someone else, lick their blood, go into a bedroom with them, and then point out a gun to them. Remember, she testified that she went around to the bedstand and was like, hey, Stacy, look, a gun. Why would you do that if you had just witnessed all of this? It is patently absurd that someone would witness this vicious and unnecessary and unjustified killing and then go sit in the car outside of the house and just wait by themselves. To play Uber driver afterwards? No, you drive off. You immediately leave and you go to the police or you go somewhere. You don't stay. And it is patently absurd that someone would sit in the car with their cell phone, with their phone. Okay, you don't trust police. I get that. But you text your sister, who's your best friend, who you were just texting with 2 to 3 hours beforehand, sending them a picture saying, oh my God, we're at this random guy's house. You text Javi, you communicate with someone. It is also patently absurd that someone would sit in the car and wait for a vicious, violent, and unjustified killer to come back out so you can bring them to your grandmother's house. And we know they went there. It matches Dickerson's phone. And it is absurd, so absurd, that even during her proffer, that was one of the very few things Mr. Burrows actually called her out on. He gave her a heads up that that was going to be a hard question that she was going to be asked and needed to come up with an answer for. She did, right? But even that answer just runs afoul to logic and common sense. She told you that the abuse, quote, got worse after Mr. Dickerson's death. And that's why she didn't go to police. And I agree with Mr. McCormick. This case, this trial, way deviated away from Mr. Dickerson and what happened. But who did that? These guys, right? We didn't. Hosanna said that the abuse got worse after Mr. Dickerson's death, and that's why she didn't go to the police. Ladies and gentlemen, worse than being hit by a car 3 times? Worse than being hit and being flung after you've been chased through an open field? Worse than when you have a knife to your throat and you're being punched in the face and you have cuts all over your body? And if that is true, if that's true, Detective Burrows told you over 51,000 pictures on that woman's phone. She even admitted she loves taking selfies. Where is a single picture of any of those injuries? You heard about getting not one, not two, but 3 different types of records from her phone. 2 Cellbrite dumps, iCloud, not one single picture of an injury. You heard about also Facebook messages. You've seen a ton of messages between those two. And common sense, experience, reasoning tells us we know what domestic violence communication looks like. You know there's the period of gaslighting, the recognition of doing wrong, causing some sort of harm, some sort of disagreement. Thousands of messages back and forth between these 2 women, and not a single one was presented to you that backs up what Hosanna is saying about domestic violence. And common sense tells you if someone goes through the process of planning, of taking these diary notes to document this domestic violence, why wouldn't she take a single picture of herself? Not one? And we also know that Hosanna told Detective Burrows that during the proffer that at one point her daughter came in while she was changing in the bathroom and she saw bruises and cuts all over her mom's body and said, "Mommy, what happened?" And that Hosanna told Detective Burrows that her mother at one point also asked about the bruise. We know again that she's incredibly close with her sister. Yet the prosecution did not bring a single one of those people in to testify that they saw anything, ever, because it didn't happen. You even heard about them getting pulled over, right? Remember the October 25th is the diary entry with the knife to the throat that she says she was punched and clothes were cut off. She told Mr. Burrows it happened a week before her deceased father's birthday on October 25th. Yet, October 23rd, they get pulled over. Where's that police officer who comes in, who's a trained professional, who knows the signs and symptoms, who isn't just going to turn their back when they see a woman with a black eye? Where's those officers? Instead, the only picture of domestic violence you saw was her face completely covered in blood. And you heard from her best friend since 7th grade who saw Stacy show up at her door after running from Hosanna. Now, the prosecution can ask Ms. Varela, or they did, are you some sort of mastermind? Kind of joke about and gloss over these diaries that she wrote. But it's a fact, ladies and gentlemen, a fact that not one single diary documenting domestic violence came until after October 3rd, when Mr. Dickerson died. And Hosanna actually kind of slipped up at one point, right? Because she earlier testified and admitted that she wrote those knowing the investigation was going on. She even mentioned seeing about the house being burned down in the media. A house is burnt down. You know that there's going to be some sort of investigation about it. And then that changes, right? Because when I confronted her with the fact of one of those messengers saying something about the truck being hot, right, and her not wanting her kids in it, then that changes, right? And she changed it to a different reason of saying, well, that the truck was hot for a different reason, but that she couldn't articulate why. And if Hosanna Varela started to write these diary notes truly because she was afraid that Stacy was going to kill her, and because of domestic violence, why is there not a single entry from before October 3rd when she told Mr. Burrows that the summer of 2021, the abuse got worse? But we had to bring in the rest of those messages, right? We had to question her about that. Like the one on June 26, 2021 that said, quote, "I love Stacy. She's helped me through things no one ever could have. She's seen me at my worst. She saved me," and saved me is capitalized. "She was there when I felt alone. Only her. She would stay up and actually listen and care. She helped me through so much." And instead, the only complaints that she documented in any of those diary notes, any of them from before October 3rd, was the one on July 11th when she's complaining about the audacity that this 19-year-old promised her that she would work 3 jobs to support her, clean her house, take care of her, and didn't. What a true reflection of the dynamic of their relationship, right? And then there's this also argument that, well, Hosanna says she wasn't afraid of being killed herself, but she was afraid that she was going to kill Javi, and also because Stacy's so jealous, and that's why she killed someone, right? All this jealousy. That's the other reason why we're here. Then how do you explain Defense Exhibit RR and SS? Remember, those are the snapshots where Stacy knows Hosanna is going to have sex with Javi. Is she jealous? Is she killing Javi? Is Javi dead? No. Stacy just says, "I put some condoms in your bag, be careful." That's not consistent with their theme and theory, right? And it also shows you how subservient she is to Hosanna. Think about, at 19 years old, you're in your first relationship, and you know this person is cheating on you. And all you say is, just be careful, here's some condoms. Ms. Rodriguez is not on trial for domestic violence. She's not. She's not charged with it, which one could argue they believe everything that Hosanna has said. Why isn't she charged with that as well, right? And collectively, if any of Hosanna's claims concerning Stacy's threats to her or Javi were true, any of it is true, you would have seen evidence of it, and you didn't. It's just her word. In every instance of Hosanna, or every instance of domestic violence that Hosanna described to Mr. Burrows during her proffer of domestic violence involved her being drunk. It's very clear this woman had a serious drinking problem. She even wrote in her diaries about using Coke 4 times a week and being drunk all the time. And what's really concerning about that is the fact that as she's describing to Mr. Burrows during the proffer of all of these instances of domestic violence, she leads him to believe that one of those included that night at the Clarion. And you heard her testify that she had read the police reports from that night. She knew that not to be true. She knew that the police went back, pulled the video surveillance, and see her heavily intoxicated, stumbling, falling face first into a radiator on the wall, when Stacy's over here trying to help her walk in. She knew that that wasn't true, and yet she goes into that proffer and says, "Mr. Officer, let me tell you about this instance of domestic violence." Then there's also her dramatic claim of, well, I couldn't even move a finger, right? She couldn't go to the police. She couldn't do anything because she couldn't move a finger without Stacy being there. She told Mr. Burrows, and she told you about these times where Stacy was waiting outside of Javi's, where she was waiting outside the street. Then there was a dramatic claim about her even going to Human Being and Stacy having a tracker on her phone. Remember that? And how Stacy went back to Human Being and asked the person how many coffees she drank. None of that's true. And you know that's true because we showed you screenshot, Facebook messages where clearly the two women were not together after October 3rd. Even in her own words, when she kind of slips up because she says, well, I had nothing to do with the burning of the items because I took Stacy's Tahoe and I drove to the gas station, got me some Mountain Dew, got me a snack, and went for a ride, took my time before I went home. Don't forget also, there's a time where an Evans police officer texts her, right? Texts her and says about an unrelated case. Does she respond to them then? We know Stacy's not watching her phone because, again, if the whole theory is that this woman is so crazed and jealous that she kills someone for merely giving Hosanna more attention, then don't you think Mr. Mob Trujillo would be dead? When Hosanna is doing nothing but texting him after seeing Mr. Dickerson's death, including sending nudes? Now going back to the jail letters, obviously there's a lot of dispute over who wrote these jail letters, right? But ultimately, nothing in those letters say anything about this not being self-defense. Nothing. And Hosanna told you as part of her testimony that Baby Joker is Stacy's gang name, right? She told you that Baby Joker was Stacy told you, excuse me, that Baby Joker was what the other girls in the pod at the jail started calling her after she arrived to the jail. Not a gang name. Logic and common sense tells you that if she was in a gang, in the past 4 years, Detective Burrows, the gang unit, would have figured it out, been able to bring you in a picture, tell you the gang name, show you a picture of her in colors. She's not in a gang. And if she was in a gang and she did go by Baby Joker before October 3rd, then where is a single Facebook message or communication between Stacy and anyone where she signs Baby Joker? Ever. Let's talk about now Hosanna's description of the progression of the events. And there's been a lot of back and forth on this. You heard that Ms. Varela's proffer was 7.5 hours long. And you heard that it wasn't until about 1 hour and 42 minutes into her proffer that she told Detective Burrows that Stacy grabbed the beer bottle, went to smash it on Mr. Dickerson's head, and that's when she told Stacy, no, don't do it. Stacy disregarded her and smashed it on Mr. Dickerson's head again. And then, so 2 times. And then 2 hours later, it's something different. Then there's this missed attempt, and then there was, Christopher may have been also trying to get a bottle. And then there's debate as to whether, in Hosanna's mind, whether or not Stacy used 1 bottle or 2 bottles. It could have been the same bottle. The point is, it's hard to keep your story straight, even in the same proffer interview, when it's not the truth. That's the point. Just like she described the different moments and her inability to keep it straight when Mr. Dickerson is yelling, "Get out of my house." Remember, to Mr. Burrows, she said that after the bottle was smashed on his head, that was when Chris yelled, "Get out of my house." But yet she takes the stand and tells you something. She tells you that after Stacy pushes him off of her, that's when he yells, "Get out of my house." And of course that had to change. It had to change because their theory is that Mr. Dickerson apparently was knocked out at the time because of the high BAC and the head injury. Well, you certainly couldn't have been yelling then after she smashes him in the head to get out of my house, right? And honestly, the bigger problem with Hosanna's description of events leading up to Mr. Dickerson's death is it simply just does not match the physical evidence. It doesn't. There's been a lot of discussion about the broken glass, right? Use your common sense. If you hit someone with a glass beer bottle, with this, you are going to end up with a large chunk, not tiny shards of glass that can't be tell the difference as the arson investigators and officers are scooping through it and sifting. And there was this weird kind of testimony by Detective Blair. The prosecution was trying to get him to say that he couldn't tell the difference between brown, dark brown Budweiser bottle glass and clear glass that was ashy and wet. We brought in that picture from that evidence viewing. Common sense tells you, you can tell the difference between a clear glass from a window that's dirty with black soot and that. Regardless. The bigger problem is the lack of injury to Mr. Dickerson's head. Because we recognize Mr. Dickerson's face is not there anymore. She's not getting up there and denying tampering with a deceased body. She's not. At no point was anyone trying to say that there was lacerations or cuts to his face. No. You heard Dr. Burson testify that he does a systematic layer by layer approach to his autopsies. He even showed you how despite the skin on the neck being burnt off, he was able to go layer by layer by layer, and you saw the pink. And he was able to show you the injuries. He did the same thing on the head. He testified that he even was able to still see hair, that he does the scalp, and then he does the meninges, and then it goes down and down. And he also testified that this type of injury, when someone's smashed in the head with a bottle, it's a blunt force trauma to the head. And that would have caused hematomas, skull fractures, contusions of the scalp, hemorrhages. Those are all abnormalities and signs of injury underneath the burnt part of the scalp. None of that. He testified that there was absolutely no evidence of any abnormality to support any injury to Mr. Dickerson's head. And that's because the physical evidence just does not support or corroborate what Hosanna told you happened. Also, just like Hosanna's word is the government's only evidence to support their theory that this couldn't be self-defense, and also that Stacy stole the ring, the debit card, and the phone. Remember that? She testified to you all under oath more than once that she saw Stacy rummaging through Mr. Dickerson's pocket as he laid there dead and gargling on his blood, right? She testified under oath that she saw Stacy steal a wallet. This wallet. She told you under oath that she saw this being taken from his pocket. That's not true. It's just not. Then there's also the claim that Stacy stole the Walmart gift card that she later used to purchase bleach, which we know she's not allergic to. She worked at the COVID sanitation JBS. That's not true. But she went to Walmart, paid for the bleach with a stolen gift card, right? The stolen one Walmart gift card. Then how do you explain the $100 master gift card, the other Walmart gift cards in here, the 8 other gift cards in here? Why would she go through the trouble of rummaging through his pocket to steal something and only take one thing? Then there's the phone, right? She claims Stacy took 2 phones, stole 2 phones. Mr. Burrows testified that none of Chris Dickerson's family members ever said that there was ever more than 1 phone taken. Again, another point of exaggeration, right? But I submit to you, who do you think really took that phone? You heard that Google locations had the last known registered location of that phone 2 blocks from Hosanna Varela's grandmother's house. We don't know if the ring was there. We don't know if the phone was there. Why? Because they did not ever get a search warrant for that house. And Mr. Burrows got up here and gave you a story about how, well, I have to have belief that that's there. It's a dead person's phone 2 blocks from where you know, and you wrote in your summary. You knew Hosanna Varela's grandmother lived 2 blocks away. You get the search warrant because you know what? You're accusing someone of first-degree murder. You're accusing a 19-year-old girl of first-degree murder. You get the search warrant because it doesn't hurt to. You don't get penalized. Then there's the ring. Common sense tells you, you can't burn a diamond ring. You can't burn metal. Also, we don't even know where that ring was leading up to October 3rd. Alan Dickerson testified that he knew his son was engaged. They didn't really talk about it. He knew he got the ring back. He knew he had seen it there at some point. But we also know there's an SD card in that box. There has been absolutely no evidence that that ring was there to even be taken. And I would also point out to you, who do you think had more incentive to take that? The person, the 19-year-old girl who has a family to go to, a place to live in, a car, a job, or her co-defendant who got fired months beforehand, has no income to support her children, whose car got repoed, who got kicked out of her family member's house, who isn't working. Ultimately, when you take a step back and look at the whole picture, just like we spoke about at jury selection, all of this matters, all of it, because the only evidence they have is that girl's word. And as the judge explained to you in jury instructions, not only does the prosecution have the burden of proving that Stacy had intent to kill, and after deliberation, and after time for reflection, and after judgment, but there's more. There's an added layer. Self-defense makes their job harder, because now they also have to convince you beyond a reasonable doubt that Stacy did not act in self-defense. They have to convince you that you are firmly convinced that what Hosanna Varela told you was the truth. And you have to consider her motivation. The law tells you that. You heard from Miss Mary Claire Mulligan. Of course she's a defense attorney, right? She's not sitting at our table. Of course she's a blind expert. But she explained to you that with 33 years of experience, state courts, federal courts, that the proffer that Hosanna did, that's what this looks like. Proffers are given when they have a hole in their case that they need to fill. Detective Burrows even went in and told Miss Varela, I have a hole. I don't know what happened inside the house. And she told you, Ms. Mulligan did, that it would be unethical and against a lawyer's legal duty to do no harm to their client, to walk a client into a police department accused of first-degree murder and give a 7.5-hour proffer about how they were there and what they did and not get any benefit from it. That's just not logical. You would never pay an attorney, you would never hire an attorney to walk you into a police department and be like, yes, officer, let me tell you about how I was there and helped burn down a house. Obviously, there was a benefit. And the problem with that, and the reason why the court instructs you that you have to consider that motivation, is because it makes someone have this carrot dangling in front of their head, or in front of them, right? Remember Ms. Mulligan explained to you that this whole proffer process, the co-defendant has to keep that person happy. They're the ones with the power, right? And so she's sitting in jail on first-degree murder, not able to bond out, thinking of her children. She has to make that person right there happy. He has the power, and he continues to have the power as she's standing up there testifying. Because don't forget, yeah, she got that 16 to 32-year deal that Ms. Mulligan testified was a phenomenal deal, coming down from first-degree murder. But then there's also part of the agreement that if she testifies as to what he considers to be truthfully and completely, then she gets to come back before this court who just heard her testimony, making herself seem like some sort of collateral victim, and say, Judge, please reduce my sentence. She could walk out next week based on that testimony. She could go home to her children next week, right? I know I've had your attention for quite some time, and this has been a long trial. It has been. I just want to finish up by pointing out that during cross-examination, Mr. McCormick asked Ms. Mulligan about how and wouldn't it be that a DA would presumably go back and evaluate whether or not a co-defendant proffered the truth? Remember that? That it would be irresponsible for a prosecutor or law enforcement to not do that. They didn't do that in this case. They didn't. If Ms. Varela is telling you that a beer bottle, a glass Budweiser beer bottle, was used to smash him in the head and you only have one in evidence, you send it out for lab testing. It's routinely done. That's what the lab is for. They will be able to tell you, is there blood on it or is there not? And if there's not blood on the beer bottle, okay, nothing changes. You only do not send out something like that for lab testing in a first-degree murder case because you don't want the truth. You don't. Ladies and gentlemen, there's just way too much red flags and inconsistencies and dramatics with Hosanna Varela's story to ignore that. Just like, why wouldn't you get a search warrant for Hosanna Varela's grandmother's house? You're accusing a 19-year-old kid of first-degree murder, and then you stand up here and blame her for not telling Detective Hunziker in the parking lot, for not telling Detective Hunziker the truth. And then you criticize her and chastise her for having a fear of law enforcement, right? Does anyone else not see that that's true? No one at that table was ever going to believe her after she did that to Mr. Dickerson, that it was self-defense. Who could blame a 19-year-old kid for lying to the cops about what just happened? She was terrified. But when you're talking about judging her credibility and her testimony, think about the fact that she could have gotten on the stand and told you Hosanna did everything, right? She could have gotten on the stand and they don't know from the video surveillance which one person went back into the house to burn it down. Watch the surveillance. You can't tell. No one told you they can tell. She could have gotten on the stand and say, ladies and gentlemen, that was Hosanna. Hosanna did everything. I did nothing. Instead, she took the stand and she told you, I made some really bad choices. I burned the house down. Find me guilty of arson. Find me guilty of tampering with a human body. Find me guilty of the burglary related to arson. At the end of it, she got up there and she told you all that she acted in self-defense, because she did. This is not first-degree murder. It's not second-degree murder. It's just not. Again, let us take things as we find them. Let's not distort. Please find her not guilty of first-degree murder and burglary for the items from Mr. Dickerson's house. Thank you.
All right, thank you. Does the state have any rebuttal argument, please?
Your Honor, if I could just set up.
Sure.
For nearly the last hour, you've been given an illustration as to what reasonable doubt is versus what it's not. And when all else fails, it's pretty simple. Blame the victim. Blame Christopher. That's the solution. His shirt says everything you need to know. Seriously? We're going to blame him? We're going to say that he deserved to be stabbed 5 times? We're going to blame Hosanna? And the simple answer from the defense was yes. This is supposed to be a truth-seeking process. And it resorts to blaming him. And it's not supported by anything, using reason and common sense. And your life experiences. Now, we know that the elements of murder in the first degree, in large part, are satisfied because of the simple aspect of self-defense. We know the defendant got caught after hiding for a month, playing hide and seek from police. No calls, nothing. After burning his body to cover it up. And we know that she acted intentionally and after deliberation. Now, ladies and gentlemen, you have the instruction number 13. If you need to go back to it, you can. And in instruction number 13, that lays out the law for you on the mental states. You heard the defense get up here for the last hour and talk about planning, and that word does not exist in that instruction. Look for it when you go back. Exercise of reflection and judgment concerning the act. Never one that's hasty or impulsive. But it doesn't require planning. It doesn't require premeditation. It requires an appreciable amount of time. Doesn't have to be long.
Objection, misstatement of law.
All right, can the parties approach?
And that anytime you're back there and you're discussing something that's vague, or you're speculating, or you're imagining, that's not what we're dealing with. What we know is on October 3rd, 2021, the defendant was guilty of first-degree murder at the time of the arrest. The defendant is guilty even without Hosanna Varela. And I want you to think about that in looking at words and actions. In light of your observations and experiences in life. Go back to the day that you were selected when you knew none of the facts prior to opening statement. And if you would have been told that this person was turned into that, with that in his neck, after being stabbed 5 times, using your reason, your common sense, hearing that his phone was taken, you still would have found the defendant guilty of first-degree murder. You would have heard the autopsy reveals this blunt object, where a handle is on one side of it, and a blunt portion is lodged so far in his neck that it has to be cut out during an autopsy. You would have found the defendant guilty of murder in the first degree based on those facts. The method of the killing, the manner of the killing, the number of the stab wounds. If you would have just heard from Dr. Burson as it pertains to how this weapon was and that the blunt end was lodged in his neck, and the degree of force, the effort, the intent, the purpose, those are the hard facts that you would have. The fact you would have to know and hear from Dr. Burson that you did, even without Hosanna Varela. The amount of trauma to his neck. What other picture could demonstrate to you a person's intent and their deliberation? And that's one of them to a carotid artery. And there are 4 others in a very small region of a person's neck. And then you would have heard that before the fire, everything is laid out on a bed with an open ring box. Where the victim's dad would have to discuss that ring. And then we hear specifically how we got there in this Chevy Malibu and connecting it downtown. And you can consider the fact that the defendant would have got up and still said to you, I don't really know cars, makes, and models. I don't know Chevys. I don't know Malibus. And you'd have the objective evidence that they take this, they come back, they light it on fire, they switch cars. That all of this goes back to the defendant. All of it. That's the evidence you would have had without Hosanna Varela. And you would have convicted of murder in the first degree right then. And you still should. But now this is morphed from a whodunit. Once they get caught, and Miss Rodriguez knows she has to pivot. And she has everything on the line. And you are able to look at the credibility instruction. And specifically, that credibility instruction is number 7. I think you should look at it. Because you have an immense power in this case, individually and collectively, that you are the sole judges of credibility. And what does that mean? You decide what you believe. You're to consider all the testimony and the circumstances in which they testified. Consider that person's knowledge, their motive. Who has the most motive, ladies and gentlemen? The defendant. State of mind, demeanor. You watched her testify. How would you describe that demeanor? And her manner while testifying. The strength of that memory at different points. Think back, go back to instruction number 7 when you are deliberating. I will be shocked if you believe a single word out of the defendant's mouth in that rehearsed testimony that was like a theatrical play with a systematic order.
And I'm sorry, Mr. Praley, I couldn't hear the objection.
Can we approach, please?
Yes.
And so when we get into self-defense, it's pretty simple. You have to be convinced that the defendant was a reasonable person, that she took reasonable actions, and what you're provided on each of the self-defense instructions is this language. Specifically, that the reasonable person standard requires the defendant to appraise the situation as would a reasonable, sober person. The defendant was neither reasonable nor sober on October 3rd. And each of you have to take that into consideration. And so if you decide, well, you know, maybe she overreacted because of the alcohol, then that's not self-defense. Had she not been so drunk, she might not have acted that way. She put this booze in her body. She doesn't get the benefit of then using it as an excuse. So let's talk about credibility of the other witnesses, and specifically what's been laid out by Hosanna Varela. She stated Chris was given vodka versus water. Ladies and gentlemen, this was a setup for Chris. She stated that Chris never had this weapon in his hand. You know, the defense today wants to talk about this file that's been described throughout this time, where it's used for sharpening knives, or it's a file for other things that has this handle. They want to call it a shiv today. But ladies and gentlemen, think closely and clearly. How would self-defense have been detrimental to Hosanna Varela? What motive does she have to lie if she's trying to run out of this house and she gets pulled back by this man and her girlfriend defends her, saves her? If that was the truth, why would she not do it? Why would she write later that she witnessed this horrific murder if it didn't happen that way? She said there were no threats whatsoever to hurt them or to kill them. Again, ask yourself why. That no physical force was ever used against either of them. And that Mr. Dickerson was yelling for them to leave, that they could have left, that Ms. Varela was asking them to leave, and they didn't. And so, ladies and gentlemen, when you look at that, just there, that supports direct evidence and circumstantial evidence throughout this case that shows this wasn't self-defense. She said she wasn't afraid of being hurt. She gives the progression of Mr. Dickerson being hit with these beer bottles twice, that she again asked the defendant to stop, that they should just go. But most important, ladies and gentlemen, there was no need to kill him. How do you overlook that? You simply can't. Because true self-defense, where someone is taking another person's life, requires that necessity. No other options. And it's simply not here. You have the progression.
So she's pretty quick now. Is she on top of him, or where is she at?
I don't think she's on top.
Okay, so she's standing. She's kind of standing, and then Chris is on the couch.
Yeah, and I think he's trying to get up. I don't know.
Okay.
But and then she grabs the beer bottle and goes to hit him, but then she misses. And I go, no, don't. I go, let's just leave it. You know what I mean? Like, let's go. And she looks at me, and she I think she grabs another beer bottle, has that same one in her hand, and then that's when she hits him on the head, and gets another one, and then hits him again, and there's blood and blood on his face and like everywhere on him. And
Okay. Let me.
Again, if that wasn't true, why would she say it? If Mr. Dickerson deserved to die, was threatening them, trying to kill them, that would have benefited Hosanna Varela. It would have benefited Hosanna. It would have benefited the defendant. Two birds, one stone. And you need to look at that using reason and common sense. And so ultimately, you're going to be able to go through the instructions. I'm just going to highlight some of them for self-defense. But here's what you need to know of where we're at. The burden of proof always rides on the prosecution. And when the defense is claiming self-defense, they're admitting to the act, and therefore it becomes the prosecution's burden to disprove one element of self-defense. And you should each know that if the prosecution, and when we disprove one of those elements, you are to return a verdict of guilty. And each of you can decide which one you believe the prosecution has disproved. You need not all agree on the same one. So, for example, some of you can say right away, I don't believe that it was a reasonable amount of force. I don't believe that there was actually imminent force that was happening. So if you don't believe that it was reasonable, you're done. You sign guilty for first-degree murder. And so, with the fact of Hosanna Varela, if you believe Mr. Dickerson never had that weapon, which there's nothing to support that he did, the defendant had absolutely no injuries any which way, never calls police. What evidence is there that he ever possessed that weapon? There's no physical evidence. And then the testimony from Hosanna supports that. He never had the weapon. He never threatened them with the weapon. He never was going to use it. Imminent. Common definition. It had to be then. It had to be now. And we know from the progression of Hosanna Varela that there is this sequence of events with the throwing of the beer bottle, the smashing of the beer bottles, and now the defense talks about, yeah, we admit to arson, but you would have been able to see it on his head even though they burnt it beyond recognition so that they had to be identified by dental records. Ask yourself why. But if you don't believe that one, let's just go with the fact that there had to be a reasonable belief that a lesser degree of force was inadequate. Think through that. A reasonable belief, a reasonable sober person's belief, that you needed to plunge this file into his neck 5 times. That had to be necessary. So if any one of you right now is thinking, yeah, I don't think that was necessary, I don't think that was reasonable, the people have disproven that element of self-defense. And then it had to be an appropriate amount of force. You have to believe that everything that you saw during that autopsy was appropriate.
Objection, misstatement of law.
All right, I'll overrule the objection.
Was there a prong 3? Is there a reasonable belief that there was an imminent danger of being killed or receiving great bodily injury? Hosanna Varela makes that pretty clear. That during this progression, she was asked to retrieve the weapon. She was asked by the defendant to retrieve this weapon. That she heard the stabbings, that she saw Chris bleeding to death, and that after the defendant moved him to make it look like self-defense. She's then told to go out to the car, sees the items that were taken by the defendant. They drive off to the gas station, they return, and that she stayed in there. And so you should look at all of that and say, what is the motive for that? And how is that consistent with self-defense, and how is it inconsistent? Why admit to what you did, what you didn't do, if that's not the truth? Prong 4. People have disproven self-defense if you believe that the defendant provoked this. And I think there's ample evidence of that for you. And then prong 5, that is probably one of your easiest ways to disprove this, is decide on your own, who do you think was the initial aggressor here? And you get to look at all of the actions after, you get to look at the evidence of flight, you get to look at the evidence of arson, and the defendant's multiple statements to a variety of people. All for what? Now, there is this discussion of Hosanna being this mastermind. And essentially, you do have to find her to be so incredible at convincing you of something that she is a mastermind. And you have to think about the motive that she had throughout this process. And I will preface this with, if you have a hard time believing this, if you have a hard time and you get lost, if it seems unreasonable or crazy or far-fetched, then good. That means you're acting with reason and common sense.
Your Honor, objection, disparaging counsel.
I'm sorry?
Disparaging counsel.
All right, I'll overrule the objection.
You have to have an opinion that Hosanna has this motive to just completely screw over the defendant above all else in this world. And that she has to know that on October 3rd, 2021, she witnessed a justified killing. A killing out of self-defense, knows that Stacy did nothing wrong, but that they have to keep quiet about it. And she has to avoid going to the police to describe this lawful justification of deadly force. She has to accept that she just sat in the car while the defendant burnt this down and not act on that. She has to prepare notes in her phone detailing her depression, her struggle with her families, witnessing somebody get murdered, how that's impacted her, threats to her family, all things that no normal person would ever do or want shared in front of a group of strangers. She then has to wait to be arrested just to lie to officers that this is part of her master plan, eventually, that she's going to reveal to you and convince you. She has to also count on when she's arrested that Stacy's going to deny it, even though both women at that moment on November 11th know this was completely justified. She's got to make calls to Javi about being arrested, being clueless about bond amounts and first-degree murder. And despite all this pressure on her of trying to get out for her kids and wanting to go back to her kids, that she's got to wait in custody for 247 days. And then still during that time period, care more about screwing over Stacy than getting out to her children. And then she's got to write these notes while she's sitting in jail before her proffer with all this information that she knows she's going to reveal to law enforcement. And then one of those notes has to specifically be to don't hear or see or do anything, knowing that if she came forward that she actually saw, heard, and did everything in a lawful way, that she wouldn't be charged with first-degree murder, and neither would the defendant. She's got to go to this proffer. She's got to convince this seasoned detective of over 10 years, who's able to corroborate her story throughout it, even though she's saying she saw parts, she didn't see others, she heard parts, she didn't hear others. And then she's got to keep going with this ruse and accept a sentence of 16 to 32 years to be sentenced by this judge for 32 years, a sentence that's longer than her life and her oldest child's combined. All to screw her over? And then she's got to be brought back. And that's really where it gets fun for her, because for 3 days she's going to be questioned in front of you, and she has to convince you guys. And that's all part of her plan. You get to decide the credibility of that. You get to decide how she's supported by or contradicted by that. And you get to look at her and see that mastermind.
You're under arrest for first-degree murder, arson, burglary, and tampering with the deceased body. Okay? Right? That's what you're being charged with. Stacy's being charged with that as well, too. If you want to talk to me, I'll talk to you about it. And I can understand what happened that night. Okay? It's only if you want to. You don't have to. If you want to talk to me, I'll listen to your story. I'll always listen to people's story.
Yeah.
Okay? Is that something you'd like to do, is talk to me?
Yeah.
Okay. All right.
Can we talk
We're going to talk at the station.
Okay.
Okay, away from everybody else.
Okay.
Away from Stacy.
Okay.
Is that something you'd like to do?
Yeah.
Okay. All right. I'll hear your story.
Yeah.
Okay.
Look at her quivering. Look at her look back. Can we talk away from... And who does she look back at? That's picked up by Detective Burrows. Yeah, we'll talk away from Stacy. Compare that to the defendant.
Maybe get out of the wind just a little bit.
Can you come and bless us? Thank you.
Yep.
Am I able? What are they sounding here?
I can't hear.
No, no. It's just...
And then her response is telling.
Have you been informed of what you're arrested for?
no.
Okay. Being arrested for first-degree murder, arson, burglary, and tampering with the deceased body. Okay.
Is there proof of that?
Yes.
Compare and contrast the two people in this case, ladies and gentlemen, based on all the evidence that you have. You determine credibility. If you believe that the shy, meek, mild defendant that you saw testify on direct, with all her social anxiety, just didn't have it that day, and her response was because she had a battery in her hand? Does that make any sense to you? The defense just got up and said nothing in the jail letters are inconsistent with self-defense. Ladies and gentlemen, go back to the note to flush. I hope you kept the same story. You ain't dumb. I know they're going to trick you. But if you ain't see or do or hear anything, you're cool. You know, don't give in to they shit. Stop right there. This shows how this case has changed. These two, from the beginning, had an agreement that they weren't going to say anything because they ran from the police, because there's nothing consistent with self-defense then, and there's nothing consistent with self-defense now. And it was Baby Joker's fault. It probably crossed your mind to say stuff, but then you going down too. Hosanna Varela accepted her accountability. She described what her role was. She did bring that murder weapon. not to Chris, to the defendant, after he was laying there unconscious. And Hosanna had to listen to that blunt file be shoved into his neck where it sounded like rubber and bone. And she regrets listening to the defendant on that request for that weapon. But that note tells you what you need to do. And ladies and gentlemen, you can go through the other defendants' letters. I self-defense. There's consistencies throughout them. But specifically, it deals with the situation in 220. And that's the letter. There's always been this discussion by the defense that there's other killings. But what we know is the defendant was talking about that, about having all these killings underneath her belt. And specifically, she says, this other bitch can be number 6 under my belt if you catch my drift. There's the discussions of how it's violent, time after time after time. And you get to consider that in complete contradiction to the rehearsed.
Objections.
I'll sustain the objection. Mr. Praley, if you'll rephrase.
To what you got to witness when she testified, in order to question she knew.
Again, objection.
All right, I'll overrule the objection.
They're riddled with threats to Hosanna. You can read 220. Direct threats to her and her children. All of that is relevant in comparing these two women. Ladies and gentlemen, finally, they're contending that the defendant did not commit burglary in terms of theft. And we know that ring was taken. It was there on the bed. It was described at length by Lieutenant Cobb. That would have been opened at the time of that fire, that those items were out on the bed. We know that. We know that ring is gone based on Alan Dickerson. We know that ring was gone based on Hosanna Varela. And we know that phone was taken based on the lap and the Google takeout. There was a discussion of the phone being taken out, that she went through his pockets. You also know that Detective Burrows testified at length that when he's watching surveillance video, he sees Chris bring out individual cards at the time of the bar, not a full wallet. It actually supports Hosanna Varela, doesn't contradict her. So the fact she just called it a wallet doesn't mean things weren't taken, because Detective Burrows supported that based on his video examination at the bars. And then, ladies and gentlemen, I want you to just think for a moment about burglary for the arson and the tampering with the body. How in the world are those consistent in any way with self-defense? They're not.
Your Honor, objection. The approach.
Sure. Objections overruled. Mr. Perala, go ahead and continue.
How are any of those crimes of burning a body consistent in any way with self-defense? They're simply not. And you get to look at the big picture, the totality of the circumstances. And then you also get to think, why in the world did the defendant go back to his house on October 16th? Why? She wanted to go look at what she did, where she did it. She went back to the scene of the crime, drove by to look at the place where she stabbed someone 5 times, and then went back in to burn his body. And I do want to talk about that. The act of stabbing someone 5 times. Is that at all consistent with self-defense? The number of times. Maybe 1 time. Defense wants 20. 5 times. And her testimony is that she's not looking in any way, shape, or form, and she's just hitting the same spot. Even though she says, he's kicking, she's kicking. He's pulling, she's pulling. Hands are being moved. You get to use your reason and common sense to just say that's not true. We know Christopher's BAC. We know she had access to just stab him. He's not moving, ladies and gentlemen. And then you look back at what she did in terms of guilt and regret. It shouldn't get to you if you saved your own life. You wouldn't have guilt, you wouldn't have regret. And then you wouldn't joke approximately 1 month after the fact, ladies and gentlemen. Almost 1 month. That I'll kill a motherfucker for you. Like 6 feet under. When Chris is 6 feet under. And then she says, no joke. This is not a joke. This is a sad reality that there was an unjustified killing for a person that didn't deserve this in any way, shape, or form. Ladies and gentlemen, the people have met their burden beyond a reasonable doubt to murder in the first degree, to burglary, to arson, and to tampering with a deceased body. I'm asking you to find the defendant guilty of all of those crimes as charged, and I appreciate your service. Thank you.
All right, thank you. Ladies and gentlemen, the bailiff will now escort you to the jury room where you will select one of your members to be your foreperson. Your foreperson will preside over your deliberations and shall sign any verdict form and verdict question form that you may agree upon according to the rules that I am about to explain. The verdict for the charge must represent the considered judgment of each juror, and it must be unanimous. In other words, all of you must agree to all parts of it. This requirement also applies to any determination which you conclude should be answered. Only one verdict shall be returned signed for the charges. The verdict form, verdict, and these instructions shall remain in the possession of your foreperson until I ask for them in open court. Upon reaching a verdict, you will inform the bailiff, who in turn will notify me, and you will remain in the jury room until I call you into the courtroom. You will be provided with 5 verdict forms. When you have unanimously agreed upon your verdict, you will select the option on the form which reflects your verdict, and the foreperson will sign the verdict form as I have stated. I will now read to you the verdict forms. You must not draw any inferences based on the order in which I read them. The verdict forms you will receive read as follows. Jury verdict, count 1, murder in the first degree. We, the jury, find the defendant, Stacy Marie Rodriguez, not guilty of murder in the first degree, and not guilty of murder in the second degree, and not guilty of manslaughter, and a place for the foreperson assigned. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of murder in the first degree, or murder in the second degree, or manslaughter, and a place for the foreperson assigned. The foreperson should sign only one of the above, 1 or 2. If the verdict is not guilty, then 1 above should be signed. If the verdict is guilty, then 2 above should be signed, and you should mark X in the appropriate box. Jury verdict, count 2, first-degree arson. We, the jury, find the defendant, Stacy Marie Rodriguez, not guilty of first-degree arson, and a place for the foreperson assigned. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of first-degree arson, and a place for the foreperson assigned. The foreperson should sign only one of the above, 1 or 2. If the verdict is not guilty, then 1 above should be signed. If the verdict is guilty, then 2 above should be signed, and you should mark X in the appropriate box. And ladies and gentlemen, regarding that verdict form, there would be no box regarding that first-degree arson, so you should disregard the mark X in the appropriate box. Now, as to jury verdict count 2, you do have a first-degree arson verdict question form. If you find the defendant guilty of count number 2, first-degree arson, you must also complete this section by placing an X in these appropriate boxes indicating your decision. Only 1 box may be filled in with the remaining box left unmarked. We further find, with respect to the verdict question for this count, as follows. Did the prosecution prove beyond a reasonable doubt that the arson was of an occupied structure? There is a box for yes and a box for no, and a place for the foreperson assigned. Jury verdict count 3, tampering with a deceased human body. We, the jury, find the defendant, Stacy Marie Rodriguez, not guilty of tampering with a deceased body, and a place for the foreperson assigned. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of tampering with a deceased body, and a place for the foreperson assigned. The foreperson should sign only one of the above, 1 or 2. If the verdict is not guilty, then 1 above should be signed. If the verdict is guilty, then 2 above should be signed, and you should mark X in the appropriate box. And again, disregard the language and as to that verdict form regarding marking X in the appropriate box. Jury verdict count 4, a second-degree burglary arson. We, the jury, find the defendant, Stacy Marie Rodriguez, not guilty of second-degree burglary arson, and a place for the foreperson assigned. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of second-degree burglary arson, and a place for the foreperson assigned. And the foreperson should sign only one of the above, 1 or 2. If the verdict is not guilty, then 1 above should be signed. If the verdict is guilty, then 2 above should be signed. And again, as to this sheet, you should disregard the instructions to mark X in the appropriate box. As to jury verdict count 4, burglary arson verdict question form, if you find the defendant guilty of count number 4, first-degree arson, then you must also complete this section by marking X in these appropriate boxes, including your decision. Only 1 box may be filled in, with the remaining box left unmarked. We further find, with respect to the verdict question for this count, as follows. Did the prosecution prove beyond a reasonable doubt that the structure burglarized by the defendant was a dwelling? There is a box for yes and a box for no, and a place for the foreperson assigned. We, the jury, find the defendant, Stacy Marie Rodriguez, not guilty of second-degree burglary theft, and a place for the foreperson assigned. We, the jury, find the defendant, Stacy Marie Rodriguez, guilty of second-degree burglary theft, and a place for the foreperson assigned. Again, the foreperson should sign only one of the above, 1 or 2. If the verdict is not guilty, then 1 above should be signed. If the verdict is guilty, then 2 above should be signed. And again, disregard the statement regarding marking X on that form. Jury verdict count 5, burglary theft verdict question. If you find the defendant guilty of count number 5, second-degree burglary theft, you must also complete this section by marking an X in the appropriate box indicating your decision. Only 1 box may be filled in, with the remaining box left unmarked. We further find with respect to the verdict question for this count as follows. Did the prosecution prove beyond a reasonable doubt that the structure burglarized by the defendant was a dwelling? There is a box for yes and a box for no, and a place for the foreperson to sign. Ladies and gentlemen, at this time, I have to announce who the alternate jurors are in this matter. The alternate jurors in this case are jurors 1915, Mr. Freemeyer, and juror 1885, Mr. Shar. I want to remind both of you that the designation for the alternate juror was selected before the parties and myself even knew who was summoned for jury service in this case. And this is by no means a reflection on your performance as a juror. You just happened to land in the designated seat that was designated before trial for the alternate jurors. In a moment, I will give you an opportunity to retrieve any personal belongings you may have in the jury room, and you will be excused temporarily with the thanks of the court. Now, I'm not discharging you from your jury service yet. I'm simply excusing you temporarily. Please continue to follow all of the instructions I have been giving you throughout the trial, because there is a chance that if one of the jurors deliberating unexpectedly becomes unavailable, I may be in a position to call on you to replace that juror. You may go about your lives as you were doing before you first reported for jury service, but you must continue to follow all of my instructions until my staff notifies you that you are discharged. All of my instructions will continue to apply to you until my staff notifies you otherwise. Mr. Freemeyer, do you understand those instructions? And do you agree to follow those instructions? Yes, sir. All right. And Mr. Shar, do you understand those instructions? And do you agree to follow those instructions? All right, thank you both. Please, if both of you can make sure that we have good contact information for you so that we can get in touch with you, and we will let you know both whether or not your service is needed. I'll also have my staff let both of you know the ultimate results of this trial. And thank you again. With that, I will swear in my bailiffs. Will both of you please come around and raise your right hand? Do you and each of you solemnly swear or affirm under penalty of law that you will, to the utmost of your ability, keep this jury in some private and convenient place, that you will promptly direct all inquiries or questions that the jury may have to the court, and that you will return with them into court when they have agreed upon a verdict? All right, thank you. With that, please rise for the jury as they retire for deliberations, and we will be in recess pending deliberations of the jury. Yes. All right, please be seated. All right, we'll be in recess pending a verdict or a question. I'm going to try and give them at least an hour. If the parties do not otherwise hear from the court, if you will, please return at 5:45, and we'll make preparations to release them for the evening.
Thank you. Thank you.
All right, the court will be in recess.
Hey, can you get Carter? At the courthouse. Yeah, I can go back to the office, so I'll drive back. When are you leaving? Anyway, I just have to be.
Okay. All right. Will you put the audio on and put the FTR on, please? All right, thank you. We are back on the record in 21 CR 2296, People of the State of Colorado versus Stacy Rodriguez. The parties are present as previously captioned, and the jury is in deliberations. It's now just about 10 till 6. I'm going to bring the jury back in and release them for the evening. I will have them report tomorrow morning at 8:30 to resume deliberations. We won't go on the record tomorrow morning at 8:30. I will just direct the jury to report, and they may resume deliberations once they are all assembled. And then if we have any juror questions or a verdict, we will notify the parties when that happens. If you'll bring the jury in, please. All right, please rise for the jury. All right, thank you. Please be seated. All right, thank you. Ladies and gentlemen, I'm going to go ahead and release you for the evening so you can get some rest. I'm going to have you report tomorrow morning at 8:30 to resume your deliberations. Tomorrow morning, that you can just come upstairs directly to the jury room. We won't go back on the record. Once all of you are assembled, you'll be able to resume deliberations. Before I let you go, I want to remind you that you may discuss this case only when you are all present, and you may only deliberate in the jury room. No juror should attempt to discuss this case with other jurors or anyone else at any other time except when all jurors are in the jury room. I want to remind you that my previous instructions, excuse me, I want to remind you that my previous instructions remain in effect. You cannot discuss this case with anyone. You cannot do any research or undertake any investigation or otherwise try to learn about this case or this type of case from any source other than what you have seen and heard in this courtroom. Your verdict must be based solely on the evidence presented in the courtroom and the law as I have instructed you. With that, we will release you for the evening, and we will see you back tomorrow morning at 8:30. Please rise for the jury as they retire. All right, please be seated. And the court will be in recess.